should actually end with the words paragraph 1D, 1 parenthesis small d. Right now it goes on to say, or detained for a period of not more than 72 hours. That, I don't know where that came from, but it shouldn't be there. So that should be eliminated. One sort of minor, but nonetheless, this is a substantive change to some extent, is in that same section 3, let's see, 3B, no, I'm sorry, 3C, which on my copy is page 4 of the bill. You'll see where it says, and I'm quoting here, failure of a person to abide by previous bail conditions. If there is probable cause to believe that while on release pending resolution of a previous offense, the person committed a felony, Class A misdemeanor, or driving or operating while impaired, was released on bail, and thereafter was arrested, I changed that from was arrested for to committed, because this is an issue that came up when I was on the Superior Court for, that there used to be a condition of probation that you shall remain arrest-free. Well, the problem with that is, if somebody gets arrested and there's no valid basis for the arrest, that can't be a basis for violating their probation. And so that same language kind of creeped into this, so that the real thing is you should have committed an offense, not just been arrested for it. So that's why I made that change. And then the only other changes that I've made, which you'll see, is later on in sections 10 of the bill, there's reference to the district court, and since the district court is now the circuit court, I made that change. So I guess what I'd like to do is very briefly to just go through the major changes that this bill would accomplish. First of all, it provides for very serious offenses, which are listed. It provides that if the court finds by clear and convincing evidence standard that the person is dangerous, then the court must order the person detained. Now, I remember I talked to a representative, and maybe you're going to hear from representatives of the law enforcement community who thought that it would be better to have a rebuttable presumption that there be detention in that circumstance. I have, with respect to them, I think that would go too far. To say that even if a person does not have any kind of a criminal record, if they're arrested for a really serious offense, aggravated felonious sexual assault, but let's assume they have no record, that it would be appropriate for there to be a rebuttable presumption that they'll be detained. It seems to me that just goes too far. You're depriving somebody of their liberty, and it seems to me that I would say, others may differ, but I would say at a minimum there should be clear and convincing evidence that the person is dangerous before, in this particular case, not just because of the crime they're charged with, in order for them to be held without bail. In subsection 597:2, 3B, which deals with less serious but still serious offenses, you'll notice that there is not a requirement of detention, but the judge has discretion to detain. But again, it only is if there's a finding of clear and convincing evidence that the person is a danger. With regard to risk of failure to appear, again, the standard is clear and convincing evidence. So I think what you'll see is the only places in this bill where I have employed the rebuttable presumption is in circumstances where the person has a prior history of committing offenses. There, it seems to me, it does make sense to apply a rebuttable presumption. And I should say here, one of the arguments that was made by some people in the law enforcement community was, well, under federal law, they do use a rebuttable presumption for serious offenses, even if the person does not have a prior history of other offenses. The court can say that because of the nature of the offense, there's a rebuttable presumption, and the defendant has to rebut that. Again, as I said, for the reasons I said before, I don't think that that's appropriate in circumstances where a person does not have a prior history. But where they do, and you'll see that there's in section 597(2)(3)(b)(3), there's a rebuttable presumption of a risk of failure to appear if the person has 3 prior non-appearances in a 5-year period or 2 prior non-appearances in the present case. For those circumstances, the bill has a lower standard of proof. The court has to find only by a preponderance of the evidence. Subsection C of 597(2)(3)(c) of the bill, that's a very important provision because one of the things we heard last year was there was a real concern about persons who have committed just repeat offenses, continually commit repeat offenses. And it can be, you know, it may not be a violent offense, it may be something like theft, but if it happens again and again and again, the court should be able to say that, look, this person is a danger in the sense that if we keep releasing them, they're going to keep committing offenses. And so subsection C would allow, if there's probable cause to believe that a person committed 2 prior offenses while out on bail, then the court has the authority to make that determination. You'll also notice in RSA, I think again this is an important provision, in proposed RSA 597(2) Roman numeral 4, the bill provides that the rules of evidence don't apply in bail hearings. That's traditionally been the way the law is operated. But the statute specifically provides that whatever evidence the court considers has to be reliable. So the court, you know, as an example, the court might be able to consider hearsay evidence in a particular case, but only if it's reliable evidence. If the court has some question about, is this evidence reliable, or is it just, you know, is this not worth very much, then the court doesn't have to consider it. So that, I'm happy to take any questions on any of the points I just talked about. I now want to turn to what is probably the most touchy issue about this bill, and that is the elimination of bail commissioners. Let me say at the outset that I have nothing against bail commissioners. I don't know that I know any bail commissioners personally, although maybe there are some people who have worked in the court system and are bail commissioners, and I just didn't know that. But I've heard good things about many bail commissioners. I've also heard, you know, some things that some bail commissioners do not do a particularly good job. But my point is not to, is not to sort of rank on bail commissioners. My basic point is simply this. It seems to me that if you're going to have the authority to take away someone's liberty, the person who does that ought to be a judge. I think that's, who has gone through the constitutional process of being nominated by the governor, confirmed by the council, and appointed by the governor to make those kind of decisions. And I think, I understand that there may be sort of a sympathy, for lack of a better term, element that we don't want to sort of say to bail commissioners, sorry, but we've kind of turned over a new leaf. I have to say, when I was in the court system, we went through the same thing when Joe Netto was the Chief Justice of the Superior Court. This goes back quite a while to the late 1990s with court reporters. That it just made more sense to do away with to eliminate the court reporter position and replace it with court monitors. And that was a very tough decision because there were court reporters who were really good and we liked them a lot, and we, to say that your position has kind of outlived its usefulness is a tough thing to do. I understand that. But I do think in terms of what is best for the system, it makes more sense to have professional, lawyer-trained judges who have gone through the vetting process of being appointed as judges to be deciding questions of taking away somebody's liberty. I think that makes eminent sense, and that's the basic reason for my proposing to eliminate the bail commissioners and appoint additional circuit court judges. I know you're going to hear from Mr. Head from the judicial branch, and I want to emphasize that the judicial branch has concerns which I think are entirely legitimate about timing of any of this. Whether you agree with my bill, I know there's a bill by Representative Shurtleff, who I greatly respect, that would, instead of replacing bail commissioners with judges, would replace them with magistrates. I frankly prefer the judge. That's why it's in my bill. But I certainly don't say that he's just flat wrong with the magistrates. But what I would emphasize is I think you're going to hear from Mr. Head that the judicial branch is concerned about the timing of this, how quickly can it be done, what resources will they need to do this, and those are all entirely legitimate concerns. And he's got a lot more current information on that than I do. So I hope you'll give careful consideration to what he has to say. And if this, maybe as an example, just as something for you to consider, maybe you decide that yes, the substantive provisions of the bail reform we should do, but we shouldn't make the change on bail commissioners for a period of time, so that the judicial branch will have time to adopt. And maybe you'll say we shouldn't do any of this right now to give the judicial branch time to adopt. That's a decision for this committee to make, and I certainly respect whatever your decision may be in that. That's really all I have to say. I'm happy to answer questions.
Thank you for your testimony, Representative. I have a first question is with regard to replacing the bail commissioners with judges. Do you see the judges having the bandwidth to be able to pick up that kind of a load that is currently being carried by the number of bail commissioners we have?
I do. I mean, one of the things that I think, and this is probably not for this committee, but one of the things that I think Mr. Head will tell you, and it's absolutely correct, is the judicial branch, in fact, it's hard to believe that it's over 3 years since I left, but before I left, the judicial branch decided to have a new weighted case study done, which was started, I think, before I left, but it was not completed until very recently because of COVID and some other things. That study shows that the circuit court in particular needs a significant increase in judges. And I don't have any doubt that they do need an increase in judges. So, and that's before this bill. So if we were to impose this bill now without giving them any additional resources, the answer is no, they wouldn't be able to do it. So I think they do need additional resources. My understanding from speaking with Chief Justice McDonald, and this was a while ago, and I should say this was not, I don't mean to sort of pin him down to this because we were just sort of talking informally, but from my discussion with him, my understanding was that the judicial branch was going to be asking for 7 additional circuit court judges without considering this bill, and that if you considered this bill, that would require 1.5 to 2 additional circuit court judges. And I have no reason to doubt that that's correct. Maybe it's maybe they have revised their thinking a little bit on that even more. I don't know. But the short answer to your question is without additional resources, no, they wouldn't be able to do it.
Representative Newman.
With what you just said about the requirements on the court would require 1.5 or 2 judges, does that take into consideration that the bail commissioners are available 24 hours, non-business hours, all the non-business hours?
Right.
That seems like a small number to me, but I'm not a judge or a lawyer.
Yeah, well, I mean, a couple of things to think about there. Oh, that, because actually that raises a very, very important point here. As you read this bill, understand that one of the language in, let me just find it. Yeah, the language in section 4 on page 2 says that, for example, all persons arrested with or without a warrant for a criminal offense or for driving, etc., and not released upon a summons to appear, so that what this bill contemplates, candidly, although the judicial branch would be able to, I suppose the judicial branch would be able to, if they wanted to, have night court, but my suspicion is they probably would choose not to do that. And so what would happen is the person would, if the person was arrested for a serious enough offense that the officer believed the person could not be released on a summons, and that there needed to be some bail, they would end up being held until the next morning when they could be brought before the court, which this bill requires that they be brought before the court within 24 hours. On the other hand, if the officer decided that this was not really a serious enough offense to require the person to be held, they could take the person to the police station for purposes of processing, but then release them on a summons, and that would be up to the officer.
And just as a follow-up, so they're required to see the court within 24 hours.
Right.
So now we have the situation where it's an event where the police think he's going to be held, but now it's midnight on Friday. How does that square with 24 hours and the possibility that there's not an availability of a court appearance until perhaps the following Tuesday?
Right. This does accept weekends and holidays. So you're right. There could be a situation where a person would be held until Monday morning. That's true.
Thank you.
Other questions?
Representative Janvrin.
Thank you for taking my question. I'm going back to when I was in criminal justice, when I was in college, and my understanding is that a justice of the peace is the person that is a bail commissioner, and that justice of the peace is appointed by the circuit court judge or by the superior court judge to commission bails. Is that still how it works?
Yeah, no, that's right. It is.
And as a follow-up, thank you, Mr. Chairman. As a follow-up to that, if a circuit court or superior court justice finds that that bail commissioner is not doing his job in an acceptable manner to the court, is there a way to replace them very quickly?
I don't know about very quickly, but there are. If somebody is not doing their job, sure, the circuit. The court. The court could take action to remove someone. Yes.
Thank you, Mr. Chairman, for the follow-up. And one last question for you, Mr. Representative, is that a justice of the peace is vetted by the Secretary of State, the governor, and council. Is that still correct?
Yeah, in a manner of speaking, yes, that's true. It's certainly not in any way the same level of vetting that occurs with a judge.
Representative Pratt. And who's?
Okay, I'm looking at page 4, line 25 and 26. It says 3 or more times within the past 5 years. And that's driving impaired or other felonies, Class A misdemeanors.
I'm sorry, I'm having trouble here.
So the question is, on line 25, 3 or more times, 25 and 26 on page 4,
Okay.
within the last 5 years, or failed to appear twice in the present case. So we're giving them 3 times before we actually incarcerate them?
Well, we're giving 3 times before there would be a rebuttable presumption. In other words, the person, whenever a person appears before the court will consider the issue of bail. I think this really is addressing the situations where a rebuttable presumption would arise, so that it would be the defendant's obligation to rebut the presumption.
So,
To clarify, that just means the burden on the defendant is raised after the 3rd offense to get bail.
Right. In other words, the state can come in that situation and prove, the state has to prove that there were the 3 offenses. But once the state proves the 3 offenses, let's say, the state can sit down basically and say, Your Honor, based on this, we think you should hold the defendant. Now it's the defendant. He may offer evidence if he or she wants to, but doesn't have to, and then the judge will decide whether the presumption has been rebutted.
okay, thank you.
Representative Reed.
So it's my understanding the bail commissioners already work under the direction of a judge, and they have guidelines to follow as how to charge bail and when to hold somebody. There are many more bail commissioners than circuit judges. So my concern is that, it's going to be so much more expensive on the taxpayers to replace commissioners with circuit judges or magistrates, and the defendant and the police are going to have to wait so much longer for any kind of service, and if it is, it's most likely going to be by phone, whereas commissioners show up in person, correct?
I believe that they do show up in person, yes. And as far as for anybody who knows, I'm certainly someone who is very much in favor of the idea of keeping government spending and government itself small. But it does seem to me this is sort of a fundamental role of government, deciding whether somebody should be released or stay in jail. And there have been some issues with bail commissioners. As I say, I think that there are some bail commissioners are very good. There are others that are not so good. And I think having a more professional role in making that determination would be a good thing.
And do you have any data on cases that might have been mishandled by commissioners? Is it 1 in 100 interactions, 1 in 10? Do you have any data?
I don't have that
Okay,
data.
thank you.
I don't know whether Mr. Head or someone from the judicial branch would have that, but you should certainly ask them that question.
Thank you for your testimony this morning.
Thank you very much.
Who's next? This time the chair recognizes Richard Head from the judicial branch.
Good morning, Mr. Chairman. Good morning, members of the committee. My name is Richard Head. I'm the Government Affairs Coordinator for the Judicial Branch. To start, we have no position on the policy of this bill. There are, at least to my count, I believe 7 bail reform bills that are out there between the House and the Senate versions. I did want to briefly talk about, and I appreciate Representative Lynn's comments relative to the resources and the timing as it impacts the circuit court. A couple things just to recognize with regard to circuit court. As Representative Lynn mentioned, we've recently undertaken a weighted time case study analysis, and that shows a significant shortage of both judges and I want to emphasize staff, because at the end of the day, anything a judge receives or does is ultimately getting passed through someone in the clerk's office. And there's also a significant both shortage of clerks, even at full capacity, but we, like everybody else in the country, is experiencing the inability to bring in enough people to fill all those slots that we currently have. Just some numbers, and I apologize for throwing out some numbers. Criminal cases filed in the circuit court alone, we're talking roughly on an annual basis between 60 and 80,000 cases. It's a lot of cases that get pushed through the circuit court. Last session, you also authorized and approved the repeal of what was called Felonies First. And Felonies First was implemented in, I think, 2015, and that changed the process that had existed and put all felonies would originate in Superior Court. So those would not be initiated through the circuit court. The repeal of Felonies First means that all of those felonies that are currently starting in the Superior Court will now begin in the circuit court. That adds roughly another 9,000 to 10,000 cases that are coming into the circuit court, which is already experiencing some severe shortages, both in terms of staff and judicial resources. If we take, for example, in Representative Lynn's bill, page 3, line 19, which is the list of crimes, and this is a list that's in a number of the bills that you'll see both in the Senate and House side. If you take just that list of crimes, we roughly estimate, and these are all estimates based on sort of past experience, that will result, without regard to bringing Felonies First into the circuit court, so pretending Felonies First still exists, about 2,500 new bail hearings before a judge, not currently in front of the judge. If you sort of estimate, again, rough numbers, not saying this is a per case, let's say they're very efficient, very quick, 6 minutes per hearing. 2,500 hearings, that has to incorporate 900,000 minutes into the system. And it's a system that is full. So my only message is bail reform and what you're talking with regard to these bills also has to be considered against how those get absorbed into the system ultimately. And our request isn't with regard to the policy. I understand and appreciate that a bill probably will come out of the House of some sort. What I'm asking is, and next week, I'm just going to reference a bill. I know it's not the bill in front of you today. House Bill 46 is a bill that would authorize magistrates. It does seem to make sense to take some time with Representative Lynn's bill and the magistrate bill because they both relate very well with each other. Because if you take the rest of Representative Lynn's bill, it essentially says not only those 2,500 new hearings that are going to come in under that list on page 3, but all of them, all the ones that the bail commissioners are currently addressing in the first instance would also flow into the circuit court. And that is a struggle. If that's what we have to do, we'll do it. And anytime you put something that has tight deadlines, mandatory deadlines, which you start to talk about when you're in the criminal world, you start to think, okay, what does not get done? What does not get heard? Because you have a set number of hours in the day that hearings can be held that pushes other things down the road, the things that don't have those type of constitutional or statutory deadlines. And we're trying to avoid that. But if we had to absorb it, we would, and we would figure out a way of doing it. The repeal of Felonies First, in terms of the management just of the administration of that between now and January 1 when that becomes effective, we have staff that are working on this continuously. It is a very complicated process from a court administration side of things. And so just that repeal of Felonies First has absorbed a great deal of time and capacity within the administrative staff of the court system. If we were to add on top of that, putting in a new magistrate system, putting in X number of additional hearings into the system, it is a lot to absorb. And we just ask you to consider that kind of absorption of additional caseload. You'll hear when the Chief Justice ultimately is talking about the budget proposal that he wants to present, he does try to address these shortfalls through the budget, through staff, through judges, and you'll hear about that weighted case study. But it is a lot to take in. So our overall ask is that at least some of these bills, and I would say specifically this bill, and next week I would do the same on the magistrate bill, ask that either they be retained or brought together as a study so that this can be done somewhat thoughtfully, that we have a true sort of financial evaluation, get some input from the bail commissioners, get some data from the bail commissioners, and have a more substantive conversation that I think you can have in the context of these hearings. So our ask is that this bill, and again, I'll ask it next week, and I've spoken with the prime sponsors of both those bills, that they be at least retained, if not converted into a study. I know you have a lot to do. I will end my comments there and be happy to answer any questions.
Thank you for your testimony and taking our questions. So basically what the court is saying is, would you please let us implement what you told us to do last year before you tell us to do something else?
Something like that. We're working on it.
Thank you. Representative Salig.
Thank you, Mr. Chair. I have a two-part question, if that's acceptable. I'm just wondering, right now, do the courts have enough physical space for all the hearings that they need to have without adding in additional delays?
So thank you for the question. It's a great question. So offhand, I don't know the answer. Certainly some courts, that is an issue. Rochester, for example, is a court, circuit court, and I'm talking circuit courts in this answer, is a circuit court that is actually divided so that some of the circuit court matters have to be heard in the Superior Court building, different building, actually a different town than in Rochester. So there are some space issues. We're trying to address Rochester. Last year, there was money put in for engineering study. This year, there's money in the proposed in the budget to build a new courthouse for the Rochester. That's one. We have a number of courthouses where there are some capacity issues.
May I ask a follow-up, Mr. Chair? Thank you for the follow-up. If we were to implement this bill in some capacity with some amendments, how many circuit court judges and staff do you think you would actually need to add in order to cover the increased caseload?
So thank you. So the bill specifically says 3 judges. So we have more than 3 courthouses. If we looked just at the busiest courthouses for criminal filings, we're talking, as you would expect, Southern Tier. The busiest, I think, are Nashua, Manchester, Concord, Rochester, and I would add Keene into that. So you're talking at least those courthouses probably need a judge, but, and this is, to be very clear, on top of sort of existing loads. So when the chief is presenting his budget, he's talking current sort of loads. And then when we get into staff, and we're talking about staff, you know, we would be talking about a great deal of work, and I don't want to minimize this, the work that is done by the bail commissioners. There's a great deal of paperwork, time spent by bail commissioners that would be moved into the clerk court staff. And that paperwork, the work that goes along with deciding bail that the judges are doing would get incorporated into court staff. Again, while all courts would be impacted, again, the courts with the largest criminal load would be impacted more. So I think that's where most of the resources would need to be focused. But throughout the system, there would be resource limitations. To answer your question specifically, is it 2 staff, 3? I don't actually have a good sense of that yet. And part of the goal of looking to either study or retain is to have, one, a sense of what is going to pass, so we know sort of what we're dealing with. Are we dealing with the list of crimes, or are we dealing with all crimes? And that sort of information gap is just hard to then put some data together.
Representative Newman?
Thank you, and thank you for taking my question. And when you were gathering your statistics and stuff, and I'm trying to think about due process, it seems like the 24 hour, I believe they said that the 75 hour, 72 hours in the bill that we have now was changed to 24 hours. So it seems like that's workable on weekdays. On the weekends, not so much. So when you were collecting data, did you, or would you consider, or are you considering systems, if you're going to take the bail commissioners away, that whether it's a magistrate or a judge that replaces the bail commissioners, that there would be the same access to due process that people have now with the bail commissioners?
So thank you for the question. When we were contemplating magistrates, and you heard a lot about, from me, magistrates last session in the context of the bail reforms and support for that, we were contemplating they would be available 24 hours a day, 7 days a week. We were contemplating they would not be in-person events, that they would they would become remote events. But those, in that context, we contemplated 24/7. With regard to judges, the answer would be court hours, 5 days a week.
Follow? Yeah, I had trouble turning the mic on. So the judges, I just wanted a clarification. The judges would be court hours, and magistrates would be 24 hours a day, and possibly all telephonic, some of it telephonic. Is that what you just said?
I couldn't quite hear. It's a great echo chamber you have here. I couldn't quite catch the end of it.
With the judges, it would be considered court hours, and with the magistrates, you took into consideration in your calculations that it would be 24 hours a day, but potentially telephonic would be mixed in with that. Is that correct?
Yes, I think that's right.
Thank you.
And again, so with the judges, I think just in terms of capacity, they do, just to be clear, there are things that judges are doing overnight currently. So there are warrants that are being issued by judges. There are a number of things that do happen overnight that judges are currently doing. Some DCYF petitions, and those are happening. But we are not, at least currently, contemplating with regard to bail that would be night times, weekends, holidays for the judges.
Thank you.
Representative Jamie?
Thank you, Mr. Chairman. Thank you for taking my question. My recollection from the 1990s, when I commissioned bails out of Hampton District Court for Justice Frazier, was we got a packet from the judicial branch that gave us guidelines on commissioning our bails. Could you make that packet available to the committee?
The materials that go to bail commissioners?
Yes.
I can ask.
And as a second part to that question, could you, if you don't explain it now, could you, in some sort of a narrative, how the requirements of 597:18A relative to educational requirements for a bail commissioner are being implemented by the judicial branch?
And again, I apologize, it's hard to hear.
Yeah, that's fine. The educational requirements for the bail commissioner, how the judicial branch is actually implementing that statute currently. I'd really appreciate it. Thank you.
Sure. I'm happy to include that. I'll check on the bail commissioner materials, but I'll be happy to send a reply.
Thank you for your time and answering our questions this morning.
Thank you.
At this time, the chair recognizes Melissa Davis.
Thank you very much. Good morning. My name is Melissa Davis. I'm currently the director of the Criminal Practice Clinic and an assistant professor at UNH School of Law. Prior to joining the law school as a public defender for 15 years. As director of the Criminal Practice Clinic at the law school, I supervise students representing clients in misdemeanor and low-level felony offenses. So for essentially the past 18 years, I have represented defendants charged in criminal cases in New Hampshire state courts. I think what's important to recognize initially is that this bill primarily affects people who I believe are, will be determined not dangerous and not a flight risk by a judge, maybe the next morning, maybe 4 days later if it's a holiday weekend. In these circumstances, these people, obviously may be innocent of the crime that they are charged with. Also, they may not, in the end, even if they are convicted of the charge, end up serving any jail time for these charges. These are people who, as I understand Representative Lynn's testimony this morning, essentially the process will be that they are arrested. It is then the police officer's determination whether or not to release them on the summons. The police officer in that circumstance is then therefore sort of taking the position that the bail commissioner currently holds. That police officer is obviously involved in the investigation of the case, involved in the decision to bring the charges, may themselves be a victim of the charges themselves, depending in resisting arrest cases and things like that. They will then be the person determining whether or not to issue a summons or hold someone overnight, presumably, or possibly up to 4 days with the holiday weekend. These kinds of delays cause substantial effects on these individuals. And I just wanted to share a couple of instances. Many of my clients are parents. Many of them are single parents. Even if they are not single parents, their spouse also works. And so the issue becomes if they are held for any amount of time and have to wait for a judge to see them the next morning, they're missing work. Not only are they missing work, if they have a partner who is available, who then has to watch the kids that day, their partner is missing work, putting both their jobs in jeopardy, therefore putting their housing in jeopardy, and causing a substantial interruption to this family's life. Again, these are people who would be, likely released as not dangerous to the community, who would likely be released as not flight risks, and who in the end are not going to likely serve jail time at all on these types of offenses. The other, another type of population that you're going to be hitting are people with substance use and mental health issues. Specifically for people with substance use and mental health issues, 1 day in jail is a traumatic event. It can cause relapse. It can cause trauma for them that is then something that they will have to deal with for a significant amount of time afterwards. These are people who may be making it, barely making it, but they are making it with the assistance of the services provided in the community. When they are incarcerated for any amount of time, those services are interrupted, and it's very difficult oftentimes to get them back in place. Specifically for people with substance use issues, many of them, as we know, are dealing with opioid addiction. That is, the best treatment for that type of addiction is medicated assistance treatment. But medicated assisted treatment requires medication every single day. Medication that the jail is not going to provide to every single person who says, hi, I'm on medicated assisted treatment, I need my dose this morning, because they don't have a prescription, they don't have verification this person's actually on the medication, and they may not have the resources to provide it. It means this person misses their dose, they then go into a type of withdrawal, which is very painful, and again risks relapse. The same applies for people on mental health medications. Many of these people must take medications at the same time every day. Most people are not carrying their medications around with them. So when they are held, even overnight, or especially for longer periods of time, the jails are not able to prescribe medications quickly. These people will be missing their medications. They risk then having effects of those medications, the withdrawal of those medications, but also not having those medications, which contribute significantly to other things in their life being disrupted. Finally, I will point out the number of unhoused people who may have a bed at a shelter. If they miss one night at that shelter, they lose their bed. They then have to go back on the waiting list all over again to get a bed. So these, even one night in jail is significant for these individuals in these situations. On top of that, these hearings, they may be presented with plea offers. They are unrepresented at these hearings. They do not have lawyers. They are offered the opportunity to get out of jail. These are people who may be innocent. These are people who may have defenses. These are people who may have, there may be issues with their case that need to be litigated. And their prime concern, as with all of my clients, is I need to get out of jail. And they may be taking offers and pleading guilty to things that they should not be taking on as convictions without the advice of counsel. This is especially concerning, well, it's concerning in a lot of areas. It's the consequences of that are very concerning with motor vehicle offenses, especially considering the habitual offender law. They may be pleading to major motor vehicle offenses, not knowing the consequences of that, and then have to deal with the DMV afterwards as a result because they wanted to get out of jail. Sorry, just one more point here. I think what's important to note is this also includes Class B misdemeanors. People who would not serve jail time even as a possible sentence in these matters. And so overall, I think I would urge this committee to consider possible damage of adding additional time in jail for people who otherwise would not be sitting in jail overnight. Thank you for your time.
Thank you for your testimony this morning. I just have a couple of questions. So, at the outset of your testimony, you said that they were likely, many of them were likely not guilty, likely would not serve time, likely would end up not being determined to be a danger or a flight risk. And you went on about the possible effects on these defendants, and I think a major duty of this committee is to make sure that there's a balance between the victims and defendants. But I didn't hear you mention the victims. I'm looking at the list of crimes, and these are all very serious crimes that have victims. With domestic violence, kidnapping, stalking, trafficking in persons, felonious use of firearms. And in order to get there, there's already been a determination that probable cause exists to make the arrest. So in layman's terms, it's more likely than not that they committed the offense. So how is it that you see us balancing that with the rights of the victims who also are missing work or possibly dead in some of these cases?
Sure, and I think that section is somewhat different than the section that specifically requires that everyone be held until they can be heard by a judge. In this matter, which is, I apologize, the section that says, right, all persons arrested for a criminal offense, including DWI, are not released unless released upon a summons. So that's all crimes.
Which section are you specifically pointing to?
I'm looking at paragraph, this is, on page 2, it is 597-2, the bottom line 29 through 31.
Thank you.
In regards to the list of crimes that are then, sort of determination about whether or not there is danger to the community in that situation, these things are already happening. Bail commissioners are already, and I'm not here to speak about the bail commissioners, but they're already, looking at the nature of the offenses and determining whether or not someone is a danger to the community based on the allegations that are made in those circumstances. Judges in those situations are also, when bail motions are filed, taking into account those situations. I will say that without a fact determination of what is the exact type of conduct that is being charged in the situation, whether or not that actual conduct presents a danger, is a significant missing step when you simply label everything as any type of domestic violence crime as something that should require being held in jail. I'm just going to give an example. I spoke to someone this morning, arrested for a non-violent but considered to be domestic violence type of offense, arrested and held already under the mandatory law that exists in those circumstances, Even that individual, as the law currently exists, is talking to me about how, he has 4 children. Those 4 children are at home. He can't get to work. He's the sole provider of the family, and is worried about his ability to provide in those circumstances. I can tell you that I have clients charged in domestic violence situations where not every charge is necessarily violent, or where any individual is necessarily a danger. By sort of categorizing it broadly under the domestic violence statute, you're going to be then putting even people who are not dangerous and not flight risks into incarceration. And honestly, in those situations, those people also are not serving jail time in the end either. They're getting the resources that they need from their community.
Representative Newell.
Thank you, Mr. Chair, and thank you for taking my question. With your, I think you said 18 years of experience in this, I'm curious, especially when we talk about this being at the discretion of the officer, I'm curious if in your 18 years you've seen any kind of patterns as to how bias manifests in that situation.
Excuse me, how what?
How bias manifests in that situation, or if you haven't, then that's it.
I mean, I think it should be a significant concern in this situation. I spoke about, the officer obviously involved in the situation is going to have some natural internal bias in these matters. We know that, people of color in New Hampshire are still disproportionately arrested on offenses, and I think that specifically in types of offenses that involve officers oftentimes, and so if they're the ones then making the bail decisions, I think it is concerning. Thank you.
This time the chair recognizes Trixie LaFleur. Trixie LaFleur. Anyone close to that?
Thank you. Trixie LaFave. Pay no attention to any of the vowels or the consonants. They don't run together properly. Good morning. Thank you all for letting me participate in this public hearing today. Quite an honor to be inside the Representatives Hall as well. I'm here. Over the next few weeks, this committee will hear 3 bills which seek funding to hire judges or magistrates, plus additional support staff for new hires within the circuit courts. Today's bill, House Bill 318, also seeks to eliminate the bail commissioners and hire 3 full-time judges. This bill contains a fiscal note with a known expenditure of $323,000 per judge, so nearly $1 million initially. The fiscal note also cites that additional judges would be needed due to the increased demands for hearings, and further states that support staff would be required for these judges. Our Association of Counties projects an unknown increase in costs to the county correctional facilities because of an increase in the incarcerations. The hire of these 3 or more judges appears to replace the entire bail commissioner community that serves the judicial branch as well as the 200+ police departments here in New Hampshire. 3 judges to answer the call of our police departments 24 hours per day, 7 days per week. The elimination of bail commissioners will carry a tremendous financial burden to New Hampshire's taxpayers, but it will also place an unknown cost burden on our county jails, which implies more individuals being detained for longer periods of time. There are about 80 to 100 bail commissioners presently appointed and overseen directly by the court that answer these calls. We are representatives of the judges. The updated 2020 New Hampshire Bail Commissioner Handbook, written by the Administrative Office of the Courts, is our guidepost, and it is our training. Bail commissioners are directly supervised by a circuit court judge. We respond any time of day, any day of the week, regardless of the weather. With the elimination of bail commissioners comes this question: how will our police departments be impacted by this reduction in the court workforce? Typically, a bail commissioner can assist their department within 45 to 60 minutes. Our smaller police departments must keep the arresting officer present with the defendant until a bail commissioner shows up and sets bail. Should this bill pass, it leaves police officers unable to patrol the roads and respond to the needs of their community. The service that we provide has no tax impact to New Hampshire residents. Our state shares a fiscal intelligence with 2 other New England states that uses bail commissioners in their judicial framework. The use of bail commissioners has proven to be a valuable tool with no tax burden. For the past 4 years, we have sought legislative support to help with uncollected funds that we are entitled to per the statute. Each attempt has been unsuccessful to date. In 2021, House Bill 498 was presented requesting funding in the amount of $636,000 to cover lost payments for the 80 to 100 bail commissioners that are presently serving. It was defeated. This represents less than $8,000 per appointed bail commissioner, and it did not pass. Bail commissioners have continued to perform their services, back here, to their communities, despite the numerous failed attempts to be wholly compensated. Here this morning is a request for the expenditure of $323,000 per each hire, plus additional unknown costs. This bill, if passed, would reduce the workforce at the courts by about 85%. The request makes no practical sense. It is short-sighted. It is what is in the best interest of the Granite Staters. Further along in January and February, 2 more bills will be presented, House Bill 46 and House Bill 653. These also seek additional staffing in the courts at a cost of more than $3 million. I point these out so that all staffing requests will be considered at one time. House Bill 318, House Bill 46, and House Bill 653 will add more than $4 million to the judicial branch budget if they all pass. I'm asking that this committee oppose the passage of House Bill 318. It is heavy on tax burden, and more importantly, it will leave our communities without the safety net of their police officers who will be performing administrative duties that the elimination of bail commissioners would cause. Thank you.
Thank you for your testimony this morning. This time, the chair recognizes Mr. Paul Leary.
Good morning, Mr. Chairman, members of the committee. For the record, I'm Paul Leary from Franklin, New Hampshire. I am a bail commissioner and have been for almost 7 years. Prior to that, I had almost 30 years in law enforcement. And just for the record, to be a bail commissioner, I'm required to be a justice of the peace, which means I have to fill out an application, have a criminal background check, be vetted by the Secretary of State's office, and signed off by governor and council. Then, if I want to be a bail commissioner, I have to be recommended by the court, fill out an application, have a background check, be approved by an administrative judge of the circuit court, as well as the Chief Justice of the Superior Court. So just in reference for the left-handed compliment that we had relative to our background, we are vetted to do it. Several years ago, the legislature passed that we were supposed to be trained. Since that's happened, I've had a 19-minute training, a 23-minute training, and this year I had the first, which I would call a decent training of over an hour's time. It was combined by 2 courts that I appear before. To let you know, I'm out there by myself 128 hours a week. The holidays, it goes up to 136 hours, and if you add an extra holiday, it goes up to even more. So basically, on the training that I've gotten and my knowledge that I've had is how I perform the duties. But you've also heard if I'm not doing my job, I'd be removed. So the thing is, the fact that I'm standing here as a bail commissioner for almost 7 years, I'd say I've been doing a halfway decent job and not enough to get dragged in to see the clerk, or worse still, the judge or the administrative judge or the Chief Justice. So the thing is, we are a group of people out here that are hardworking. If we look tired and beat up, it's because we answer the phone 24/7, 365. Someone needs a bail commissioner at 2 or 3 o'clock in the morning. We're there, we try to provide. My concern is if you do away with the bail commissioners, having been a cop way too long, I go back to State v. Weldy, a 1982 case involving some juveniles down in Kingston that were drinking. They hadn't been drinking. They had alcohol in the vehicle. Police officers confiscated that, took the kids to the PD, returned them back to the parents. Kids decided to go back out later in the evening, go across the line into Massachusetts, buy alcohol, come back into the state, and eventually, unfortunately, an accident happened and someone was killed. End result of the case was that it was found against the town because they said the police had a common law duty to act. And had they acted, they wouldn't have had the situation. So here we're going to say that police officers have to let someone go on a summons, and someone may be of questionable character. As a bail commissioner, we have to assure the court of two things: that the defendant is going to be reasonably assure the court that they'll appear, and reasonably assure the court that they won't reoffend. Now the police officer is going to have to figure that out before he gives a hand summons. You take a small town where you only have one police officer, you take Grafton County, get them down in the southern end of the county, and if they're going to have to hold them overnight, they're going to have to drive them up to North Haverhill. So there's an imposition on a lot of people if you remove the bail commissioners. We provide a valuable service, and I know that Attorney Head spoke about the magistrates. They're going to have a position to train the magistrates. You've got us for free, basically. We're our own support system. We provide all our own stuff, our stamps, our postage, our gasoline. Some of us, since COVID, because the Supreme Court told the bail commissioners and the police departments to work it out, we've started using telebail or remote bailing. I've done about 838 of them. I get calls from police departments all over the state because they've tried their list of bail commissioners and they can't get someone. So I take care of that and I do that bail. So there's a valuable service that's being provided. But just to let you know, I'm already coming up on 7 years, March 9th. I'm $48,000 in the hole of not being paid. So the thing is, we're the one group in the state, other than the legislatures, but you signed up at $100 a year. Now you're hopefully going to get a raise. But we don't know what we're going to get because the fee is set by, and it's in statute. The judge can waive our fee if someone declares indigency, so that even adds more salt to the wound. But we still get up and we answer the phone and we appear. So I'd ask you to consider, as Trixie happened to mention, the services that we provide. We're a known commodity, and if they really were concerned about us, they'd hire a person to train us on a more regular basis if they had any questions about the ability for us to serve as bail commissioners. And I thank you for your time, and I'm open for any questions.
Representative Newell.
Thank you, Mr. Chair, and thank you so much for your testimony. And thank you for your service. I'm curious, it sounds like you are a very devoted bail commissioner and stepped up to do something without a lot of pay. And so my question is, considering that it does end up costing you a lot, do you see that as a sustainable model that other people would want to take that on?
I'm sorry, unfortunately, I have these $6,200 hearing aids. Anyone standing here I haven't heard speak very much, and you, the last half of what you said, disappeared into the room.
I apologize. Hopefully I can make it a little clearer. What I'm curious about is if you see this as a sustainable model that other people, seeing as you have sacrificed so much to serve your community in the way of, extending your own resources, do you see this as something that is sustainable and that other people will be willing to take that on when you pass the torch?
Unfortunately, Representative, I still can't hear the
How about, can you hear me? Can you hear me?
I can hear you.
Okay, I'll reiterate. She asked if, based on the hardships you have, getting paid and all the work you put in, if you see this as a sustainable model going forward, if there'll be anyone else interested in being a bail commissioner.
It's if you truly believe in the New Hampshire way, and people believe in the common good, I think people will step up and will do it. But the problem is, after a period of time, they'll get burnt out and fed up because they're not treated with respect by the people that they're trying to serve, but more importantly, also the people that they're working with. There are some things that they could do to make it easier for us, to help in the collection of the bails that are due. An easy way would be just make it a court cost, and the court system pays us $40 every time we do a bail. End of story, we get paid, people are happy, and then we still have our own expenses. But the answer to your question is, I think the citizens in New Hampshire care enough about the system that if they know about it and they can meet the qualifications, and that's the key to it. Just because you're a justice of the peace doesn't mean you know enough to be able to sign a warrant. Just because you're a justice of the peace and you become appointed a bail commissioner doesn't mean that you have all the answers until you're either trained or you learn the hard way, the school of hard knocks. But I have faith in the citizens of New Hampshire that they will be there to step up and do it.
As do I. Thank you. There are no further questions. Thank you for your testimony. The chair recognizes Professor Scheer from himself.
Good morning, members of the committee. Thank you, Mr. Chair. I'm going to try and tailor my comments given what's already been said. I am a professor at UNH Law, professor at UNH Law. I've been there, this is my 29th year. Before that, I was a public defender for 13 years, so all told, I've been involved in the New Hampshire criminal justice system for over 40 years in various capacities. I am also recently, about a year and a half ago, elected as a police commissioner in Portsmouth. There are 3 of us, and we are loosely the board of directors for the police department in Portsmouth. So I have a variety of experiences in the criminal justice system. I'm not going to go into the cost issues. I'm very supportive of what Mr. Head said about the court's cost issues. It's a real significant problem. I get that. I don't think that portion of this bill, which seeks to solve it by adding 3 additional judges, really addresses it in a full and comprehensive way. There's staffing issues that go with that. So I would rely on, I would defer to what Mr. Head said and the court system says on that. That's part 1 of this bill. Part 2 of this bill is the change in the underlying bail statute. For purposes of background, I worked with Senator Feltes 5 years ago in drafting the bail reform bill that was passed. And I've been working with this committee, testifying before this committee in front of the Senate Judiciary Committee on bail issues for 5 years. It's something I care deeply about, and I appreciate the complications that come with it, even putting aside the cost issues. As to the change that Representative Lynn's bill proposes with adding those, I think there's 12 crimes where the system would deal with them differently and hold people until they see a judge, I think I would say most simply that over-incarcerates people without any data to support that we need to take that extra step to over-incarcerate people at the front end of the case when we know far less about the case. To capture the, and I know this committee has struggled over the years with having to make decisions without data. That's one of the fundamental problems we have in this area, is we don't have data about what's really going on. Those who've been on the committee for a while have heard anecdote after anecdote about the horrors of the bail statute. And that's, I'll be blunt about it, that's a false narrative. I worked with a student. I hired a student over the summer and this past semester to actually gather data. We gathered 508 what are called case summary sheets, which summarizes what is happening in an individual case. And we got over 1,000, and we were able to process 508 of them that tell us what's going on in the case from soup to nuts. You know, what they were arrested for, what the bail was set at, what then transpired in the case. And the story that data says, and I offer to you, this is the first data, actual hard data, that this committee has heard in 5 years of dealing with bail reform issues. What that data says is several very powerful pieces of information. Out of the 508 case summary sheets that we looked at, in only 4 of them, 4 out of 508, was there any evidence that the person who had been released on bail was charged with a subsequent crime. So this issue of, you know, the sky is falling, dangerous people, given bail reform, dangerous people are out there committing crime after crime because the bail system is letting them out, is a false narrative. There are anecdotes, no question about that. No system as large as the New Hampshire criminal justice system is going to be perfect. It's not possible. But 4 out of 508. Number 2, out of those 508 cases, there are a mix of completed cases from, I think, 2018 or 2019, from Manchester District Court and Superior Court, Hillsborough County Superior Court North, the Manchester Superior Court. We picked those because that is the most, in terms of testimony we've heard over the years, it's the most contested area in terms of bail reform. I know the Manchester Police Department has very strong opinions about it. Out of the 508 cases, 35% of them, all the charges were dismissed. 35% of them. That means if you increase the number, as this bill does, as House Bill 318 does, if you increase the number of people who are being held, at least in the short term, if not longer, by virtue of identifying these serious crimes, remember, many of them not only are people, as Professor Davis said, are people who are subsequently not going to get any jail time, many of them are people whose cases will be dismissed completely. Yet they will have spent anywhere from 1 to 4 days in jail, creating the havoc in their lives that Professor Davis talked about. Third, out of the 330 plus cases that we looked at from Superior Court in Manchester, fully 78% of them were drug cases. Relatively speaking, victimless crime cases, other than the defendants or themselves, who are the primary victims in drug cases. There are certainly exceptions to that. But 78% of those cases were drug cases. Drug cases are overwhelming the court system. And they are not the kind of cases that are, the solutions in those cases are rarely involve, successful solutions rarely involve incarcerating people. You know, I think as Professor Davis said, the criminal legal system, the criminal justice system is not good, is not designed and is not good at solving the problem of unhoused people, of solving the problem of people with significant addictions, of solving the problem with people with significant mental health issues. Yet, in the absence of other systems available, we've been trying to jury-rig the criminal justice system to do that, and it's not working particularly well. We're over incarcerating people. Finally, there is plenty of opportunity and statutory authority under the current bail statute as it exists to handle dangerous people, rather than using what Representative Lynn's bill does, is for certain crimes using a one-size-fits-all approach. The system is currently set up that judges make decisions in individual cases, and that's working based on the data that we've collected. So I encourage you not to be seduced by the false narrative that something is fundamentally wrong with our bail system as it exists. It's working. Don't be deluded by anecdote, horror stories, because they exist and they're always going to exist no matter what kind of bail system we have. But overall, the system is working really well. Finally, I am in support of Representative Harriet Gathwright's magistrate bill. I think it's, in the long term, the right approach to handle one part of the bail system that has had somewhat erratic issues, that is, bail commissioners. As I think Representative Lynn said, there are some excellent, very devoted bail commissioners, and you've heard from them, but I'm also aware that there are bail commissioners who are less available and are not real, in the eyes of both police departments and defense lawyers, are not understanding the nature of the authority they have under the bail statute. So I would urge you to vote ITL on this bill, and I will be here next week to testify in favor of Representative Harriet Gathwright's bill. I think we either need to pass that bill and extend the time of implementation significantly, or we need to put together a study committee that pulls in the courts, the criminal defense community, the prosecutors, the police, to really have a comprehensive staffing, be it judges or staff, solution. I'll talk about that more next week. More than willing to answer questions.
There be no questions. Thank you for your testimony, and we'll see you next week.
Thank you.
The chairman calls Mr. Frank Knack from the ACLU.
Mr. Chairman, members of the committee, is this on? Cool. Thank you for the opportunity to testify today. My name is Frank Knack. I'm the policy director with the ACLU of New Hampshire, and we are here in opposition to HB 318. Professor Scherer talked about the anecdotes that you've heard and that I'm sure you will hear this session around bail reform, and to not kind of look at those anecdotes as what's really happening on the ground. And I can't reiterate that strongly enough. And I think, you know, the thing that's been missing with a lot of the debate is what are the specific facts in each of those cases, and how has current bail law failed in those cases. And we have not heard any evidence of that. And so if you look in the packet that I gave you, you'll see a few things. You'll see our fact sheet, but you'll also see a document that lists by code section all of the numerous tools currently in the law that allow people who have reoffended to be held. It clarifies very clearly in black and white that anyone, under current law, anyone who is a danger or a flight risk to the community can be held regardless of the offense. And another issue that was raised last year, and we didn't get a sufficient answer, I believe, from those proponents of this legislation, is that under current law, a prosecutor, the state can challenge any release order that they disagree with. And so when we're hearing these anecdotal stories, we're not hearing in each of those cases, you know, did they challenge the release order? Because we, from our perspective, we haven't heard that they are. Did they challenge, did they use the tools they have to have the person incarcerated when they reoffended, because they have that tool right now. And so we think those are really important factors to include in this debate. The other issue that I want to lift up, among a few others, is that we've also heard that bail reform has made our communities less safe. And so while we have only been provided some anecdotes without detail to make that challenge, we've seen no hard data. And so the data that we do have right now is the data from the Department of Safety around crimes and arrests. And so if you go back to 2018, the year of bail reform, and you actually look at the crime data, overall, New Hampshire, despite the rhetoric we've heard, crime is down 18% for Group A offenses, so that's the vast majority of offenses, 18%. And in the jurisdiction where we heard the chiefs testify last year in Manchester and Bedford, in Manchester, crime is down 13% since bail reform. In Bedford, it's down over 21% since bail reform. And so the notion that bail reform has somehow made our communities less safe, again, is not supported by the facts. I also really think it's important. We had Representative Lynn talked earlier about FTAs and the fact that this legislation is further restricting the discretion that judges have around FTAs and allowing folks to not be necessarily held under FTAs. So the Rockefeller Center at Dartmouth did a study of FTAs a few years ago, and this is what they found. Of the top 5 reasons that people fail to appear, 4 of them are childcare, transportation, employment, or they forgot. And so taking away a judge's discretion to determine the facts in that case and whether or not that person should be held, particularly when 4 of the top 5 are things of these nature, we think is very problematic. And again, there are data-driven tools. So when people forget, there's lots of research going on right now around ways to handle that, like text message alerts. The MacArthur Safety and Justice Challenge has been doing this across the country. And also, I really I think it's important to point out that not only have they not provided any data to support their claims, but they're also ignoring the robust research that has been, decades in the making, including a major study last year by Arnold Ventures in Kentucky that looked at 1.5 million people who were jailed between 2009 and 2018. And so prior to this study, there was a common belief that, if you were held by more than 24 hours, the likelihood of reoffending increased because, as we heard, you're removed from your community, you're removed from your job, either collateral harms or severe. What this most recent study found of 1.5 million people over a 10-year period is that any incarceration pre-trial increases the likelihood that someone will reoffend because they're being removed from their community. And so that's not saying that no one should be held. It's saying that the way our current law is written, which ensures discretion, but that anyone can be held if the judge in that individual case finds them to be a danger or a flight risk, is the standard that we should maintain in New Hampshire. And happy to answer any questions.
There being no questions, thank you for your testimony this morning. Is there anyone else who hasn't filled out a pink card or wish to testify? Representative Sytek.
Hi, Mr. Chairman, my fellow members of the committee. I know this is running long, but it's important, so I'm sorry. I hope my remarks are worth listening to. I have been a bail commissioner for 22 years. I've done 3,375 bails. I don't want to pick, there are a couple of quick flies that I would like to swat. First, there is no form, according Judge Lynn, Representative Lynn didn't know it, didn't say it. There are no formal procedures for removing a bail commissioner. But practically speaking, all that happens is the judge calls the police department and says, don't call this guy. If you go to the judicial website, you'll see a list of decommissioned bail commissioners. I want to take I'm taking real exception at the idea that magistrates know better, can set bails better than bail commissioners. And pardon my umbrage, but look, I made it a point when I was first starting, and I still continue here and there, to check what the Superior Court does with my recommendations. In total, now I don't know how many I've done, maybe a couple dozen of checks. no judge has ever changed. I have had 2 of my bails changed. One was increased, and the other was moved from a bail to preventive detention. So I trust the bail commissioners. I heard a statistic that 4 out of 508, where'd he go? Look, yesterday, there was a guy arrested for domestic violence who was out on bail for shoplifting. I wasn't prepared to think about this, but I know there's been a couple others in the past month that have committed offenses while on bail. That's not the main purpose of what I'm saying, but I heard those remarks, it's hard to take statistics seriously sometimes. You want to, and then you see your own experience and you wonder. I am testifying in opposition to this bill. I hope my experience, I'd like to share my experience. I hope that it's helpful. I think, from what I've heard, I'm going to try to offer some different slants and mention some things that weren't talked about at all. I believe this bill will work against the liberty interest of those arrested by detaining them longer. Whether they're retained waiting for a bail commissioner, a clerk of courts, a magistrate, whoever, it's just as real an incarceration as if they were found by judicial process. I'm going to say that the present system of bail commissioners, with 100 of them covering the state, is like democracy. It may not be the best system, but it's better than the alternatives that I have seen offered. The why of this bill is important. I'm about a quarter of the way through, by the way. The why of this bill is important. Before today, bail commissioners have attracted almost no legislative interest or concern. There's been recent controversy concerning bail reform, and it continues today. HB 38, I think, coming up. Bail commissioners have been caught in the crossfire of competing considerations and in effect have been held responsible for cash bails, excessive cash bails. In my experience, this is not so. Bail commissioners follow their instructional handbook and the instructions of their district court judge. They follow the rules. At a conference a couple of years ago, look, I live in the real world. I've done this for a long time. At a conference a couple of years ago, I won't mention the judge's name, he said, I don't have the exact quote, but it was like this: I don't know exactly where we stand on all this. Talking about judicial form, cash bails, all of that whole miasma. So what is likely to happen? Right now, let's see, where am I? For a bail includes the right to speak to the bail commissioner about their bail conditions when cash is involved or otherwise. In the proposed system, the arrested person will wait longer. And we try as bail commissioners to be there within 30 minutes or 45 minutes is the kind of time. If it's longer than that, we pass it off. At least I do. How do I know this? From time to time, I bail somebody who's had experience in Massachusetts, and you'd be amazed at how many suspended licenses this occurs. They are amazed when they see me, and they thank me because they say in Massachusetts they have waited hours for the clerk of court to show up. The proposed system will soon likely spring a leak. What I mean by that is this. Where were you at 2 o'clock this morning? I'll tell you where I was. I was driving to Parkland Hospital from Salem to Derry to bail a bedside bail for a domestic violence suspect. The issue was they wanted him bailed before he had an operation. In the course of the altercation, he also hurt himself. Good for him, I suppose. But they wanted him out of police custody. So I'm going up. By the way, I didn't get paid. That was just on the house. That's life. I knew that. We all knew that. It comes with the territory when we became bail commissioners. As a side note, Judge Corby asked me long ago to be a bail commissioner. I didn't know what it was. just evaluated that I had some common sense, I guess. And I did it because I thought it was a good thing to do for the community. The money was, I guess that's nice, beer money, I suppose, but it's not why I do it, or why others do. Perhaps the, all right, let me leave that. Okay, I guess what I'm talking about, I don't see a district court judge or perhaps even a magistrate getting up at 2 in the morning to afford a constitutional right to somebody who is entitled to a bail. We take that seriously. I take it seriously. You've heard that bail commissioners don't cost the state anything, but this bill will cost over $1 million. You've heard that, but what you didn't remember, what you may not have remembered, is that there's a competing constitutional right, and that's the right to public defenders. We heard when we had our orientation that the public defender's office wants $15 million. Do you think they're going to get it? Where are we going to find $1 million for this or $1 million for? It's unlikely. So I think public defenders are more important than a system that is presently working. Okay, I am reflecting personally the 4 Salem bail commissioners. I know a sprinkling of others in Rockingham County. There's no formal organization, but we talk. And I'm not very different from other bail commissioners that I know. The bill also has some technical problems, and I'll leave with that. And that is this. Line 12, page 2, if I remember correctly. So here's what happens. It's 8 o'clock at night. Guy gets pulled over. State police pull him over. He's driving, he's got a cash to settle fine. He didn't pay a $120 fine, okay? There's a warrant out for his arrest. It's a hard warrant, EBW. I can't do anything about it. The judge, if he has $120, he's freed. I write up the papers, he goes his way. You read line 12 and it tells you the court will accept this. Where's the court at 8 o'clock at night? You gonna slide it under the door for him? Just, that guy's gonna be in jail because he got an EBW, a piece of paper that says, don't let him out. If he says he doesn't have the money, you have to let him go and write him up for, mark him up for another arraignment. But ironically, the way the bill's written, if he has the money, he can't get out because he can't give it to the court. At the bottom of that page, starting at line 28, what about domestic violence? You'd be amazed at how many pajamas I've seen along the way. Guy gets pulled in at 11 o'clock at night for domestic violence. The court can set him free. You're going to have a judge come out. These are important people, by the way. They don't like to be disturbed that way. I've never seen the police call a district court judge. They're minor gods. Anyway, there are technical problems with the implementation of the bill. It would really take sitting down with real-world experience, analyzing, seeing exactly what happens after an arrest. How is it handled? And that is why I'm opposed to the bill, both from a conceptual point of view and from a technical point of view. Thank you for listening. If you have any questions, I'll be in committee for the exec session.
Thank you, Representative. That being the last speaker on the bill, I'm hereby closing the public hearing on HB 318 and opening the public hearing on HB 560. And looks like we have a co-sponsor going to speak, Stephen Bogert, Representative. The chair calls Stephen Bogert, Representative Stephen Bogert. Representative Pratt, are you introducing this bill?
Is this to present House Bill 560?
Yes.
Yes, I will do that for trivia today.
Okay, thank
you. First of all, I just handed this, so I'll read it. I'll read his statement. Everywhere it says "I," that will be from Representative Trodia. This is House Bill 560, FNA, and the bill requires the state police to establish a contact person notification program to assist the law enforcement personnel who have contact with a person with mental or physical disabilities, make an appropriation thereafter. The state police are here today. They're going to be in favor and speak to this. Today, this bill 560 is being presented in hopes to establish a contact person notification program to assist law enforcement personnel who come in contact with a person with mental illness or physical disabilities, making an appropriation thereof. As many of us have seen in recent years, there have been many negative interactions between law enforcement and individuals with disabilities across this country. Many times these interactions have been deadly and very controversial. Several states across the county, including our neighboring state of Maine, have passed a similar law which gives law enforcement another tool to avoid negative interactions with persons who have disabilities. This bill requires the New Hampshire State Police to develop and implement a program with the state police online telecommunication system, that's known as SPOTS, to assist law enforcement officers who come into contact with a person with mental or physical disabilities. This program will be voluntary based, whereby the person with disability or a legal parent or guardian of a person with a disability may supply their local law enforcement agency with certain information pertaining to the person's disability, such as autism, hearing impaired, Alzheimer's, and other disabilities, and who the law enforcement officer may contact during an interaction with such a person. The law enforcement agency who receives such information will enter the person with disabilities in the New Hampshire State Police SPOTS database. The information entered into the SPOTS will be available to all law enforcement agencies across the state of New Hampshire who has contact with a participating person. At any time, the participating person or the legal parent or the guardian of such person may request the person's information to be removed from SPOTS database. The goal of this program is to give law enforcement officers a resource to avoid negative interactions with persons with a disability. I am asking for the members of this committee to help give law enforcement officers a resource to help protect a person with disabilities. As a veteran law enforcement officer, the writer of this document, and a parent of an autistic child, I feel this program will be an asset to law enforcement and individuals with disabilities. After doing some research and speaking with resources from other states where this program has been developed and implemented, we have learned the cost to start this program has been estimated between $25,000 and $50,000, depending on the database and other states use. Asking for $50,000 to allow the New Hampshire State Police to develop and implement this plan. As stated in the physical note, the New Hampshire State Police would not require additional personnel to manage this program. They state it would increase the workload slightly for the current employees.
Thank you for introducing and testifying on that bill, Representative. The chair recognizes Lieutenant Matthew LaPerriere from the New Hampshire State Police.
Good morning, committee. So the state police supports this bill. Just here to testify on that behalf. It's beneficial for everyone in the state. We spend a lot of time, if we do have a situation with someone that might have Alzheimer's, dementia, autism, any of those scenarios where we're wasting hours and hours and hours, not wasting, but it's using hours and hours just to locate a family member to help in the situation. Never mind if we don't know there's a disability, situations that get ramped up and cause, further, could be injury or cost are associated with not knowing what this person has. So if somebody wants to voluntarily provide information about something that we can have in a system that when we run the person, we know what we're walking into or what we're dealing with, that would alleviate a lot for all law enforcement across the state. My understanding is this would be within New Hampshire as of now, so that's how we connect everyone, is through our SPOT system. All of the law enforcement, state, county, local, we're all connected through our SPOT system. So the financial piece, from my understanding, is we would have our vendor that handles our spots, so our software company would add another module. So this module would be one more module versus the others that we have. So if we have a missing person module in our system, this one is just one more separate module. So that's what the expense is. Once it's in there, it'll be pushed out to all agencies, all the dispatch centers and everybody. So it's a quick spin up on a system that's already been in existence for decades that everybody understands and knows how to use. So I think it's all positive. I can't see anything negative. I don't know if anyone has any questions.
Just so for the committee understands, so what this would do is if you get a call to a residence for a disturbance and there's a person there, dispatch would call that person up in the system, something would flash and say this person has this contact for this issue, and you would know before you got there what you were dealing with, and dispatch could potentially call the person to help assist. Is that pretty
That's
much
correct.
how that would work?
Because a lot of times if it's someone, say Alzheimer's, dementia even, we have wrong-way drivers. And I've been out there, you know, you get them boxed in on the high-speed lane on 93, and you're going through their wallet. You're trying to look for, because they don't even know where they are, what's going on. So you're trying to find something to help out this person because you need to figure it out. So if we have something that's in place, it helps all the way around. So either we're responding to something or we come upon it. It's a huge help.
How would someone get into the system? Is this something where a relative would have to call the state police, or could they go through their local police?
It would be every law enforcement agency in the state, just currently just how we have it. Say if it is a missing person or endangered person, that same procedure. So they go to their local police department, it'll be a form, they fill it out, it's all voluntary, gets entered, and then we have it.
Hopefully some of that money might be used for advertising, I wonder, to get that information out that this is available.
Correct.
Thank you for answering my questions. Representative. Representative Rhodes.
Thank you, Mr. Chairman. Thank you for taking my question. Pretty simply is, in the event that you know that this, you know, you're going someplace and you know that there's this contact person, that person's unavailable, what would be your next step? Would you, is there going to be a backup person, or would it just be simply you would just kind of wait until you're able to get a hold of the contact person?
So I'm just seeing this now. If it's the one person, it's the one person. However, we'll still know what we're dealing with as far as the disability, because that's a huge help. Because like I said, it could take hours just to get to that point. That would save a lot of time, especially when, across the board, our law enforcement agencies are down staffing. So I think it's just another tool in the tool chest that would help us. Yep.
Representative Murphy.
Thank you, Mr. Chair, and thank you for taking my question. As a parent of an adult child with a traumatic brain injury and autism, and over whom I have guardianship, I see great value in a bill like this, recognizing the communication disorders and challenges that these individuals have, as well as the challenges that law enforcement has when entering into a situation involving them and not being aware of a disability that may not be visual. Are you, I hear that you're supporting this bill, and would you think that having more than one contact in a system would be helpful? Should, like in my case, if the parent wasn't available, the attempt would be made to reach that person?
Yes,
en
that would be
route, or is
definitely beneficial. The more, the better. So even more than 2, more than 3, whatever that may be, it's more beneficial.
Great. Thank you very much.
Under the current systems, there's the ability to enter in more information, so there wouldn't be a problem adding more than one name or number, right?
Right, so in the SPOT system, even if you had the box without one contact, you have a comments field. So you could have, 2, 3, 4. So the system's set up that way they can add.
Representative Bolden.
Thank you. Thank you for taking my question. Is there any equivalent currently in place at city or town levels? And how does your jurisdiction relate to properties that are not on the highway for this legislation?
So in this legislation, it's being proposed that it's gonna use the spots, right? So that's the state police online terminal. That's what all law enforcement in the state uses. So Department of Safety, Division of State Police, that's what's under us, one housing of that. That's that one central point that manages it. And then from there, all the other law enforcement agencies tie into it. So this is being proposed this way because the Division of State Police oversees that. So jurisdiction-wise, yeah, we have, certain towns, Troop F, we might have 65 towns that we're the primary police agency for, those towns. Other areas, we are not. So the interstates, it just depends on who, where it is, and it's broken up in the state where you would know to go to have that entered. So up north, Troop F, they know to go to Twin Mountain. That's the point of contact for that area.
Follow up.
Thank you. So just to clarify, because you're saying all in law enforcement entities in the state use the same system, it doesn't matter where someone is found when they're in need of help. They'll their contact person can always be determined.
Yeah, through this system, it's that one system. So if I'm a Manchester police officer on my cruise and I run somebody in my mobile data terminal, that's the same thing I would have if I was a Troop F trooper on 93 in Lincoln. I get the same exact response. It's that one system. Same as a wanted person that would come up, vehicle check, all of it. It's all housed in that one system.
Representative Salig.
Thank you so much for taking my question. So this bill talks about people with mental and physical disabilities. It's not clear to me if this would also include, and I don't know if you know the answer to this, people who are having mental health impairments. So, someone who might have like a form of schizophrenia or dissociative disorders. Is that
So my understanding, just because I only read the legislation, if it's a disability, I would consider that a disability. I have had contact with people with bipolar and other scenarios, right? And that would be huge to know that that's what they are, right? To diagnose someone, instantaneously is very difficult. If you have years of experience, you can pick up on things because someone might be wearing sunglasses and it's at nighttime, right? And you're asking them questions and it doesn't make sense. So if you have this, I have a hard fact. So I would say that all those things would be welcomed.
Representative Jandron.
Thank you, Mr. Chairman. Thank you for taking my question. I have a lot of folks in my family that are diabetic. And one of the things that I think that police have had issues with in the past, if somebody is hypoglycemic, which means their blood sugar is low, they can actually act as if they are intoxicated. Would this system allow that information to be placed in there that they are a diabetic, and instead of giving them a sobriety test, you'd be able to call an ambulance for them?
Yeah, and I know exactly what you're talking about because I've dealt with it multiple times firsthand. So you don't smell alcohol, right? But the person's being very aggressive, even when you're interacting with them. And, so, like I said, however they wrote this bill, if it's a disability, I would say it would qualify for it. So if that's what the nature is, I think that's beneficial, because why do we want to have, I've had it where it has been diabetic and we recognize it soon enough where we don't, because you don't have to go hands-on at all, right? We're not gonna arrest the person for DUI if it's diabetic. So we get EMTs there and the person is more comfortable with that. So it alleviates a situation and it brings it down. So I would see benefit in that, correct?
There being no further questions, thank you for your testimony this morning.
Thank you.
Is there anyone else wishing to testify on this bill? There being none, I'm going to close the public hearing on HB 560 and open the public hearing on HB 643. Who's introduced this bill? That's who it is. I recognize Representative Hope Damon to introduce her bill.
Good morning. Thank you, Chairman Roy, and thank you to the full committee for your efforts to be here today and overall. I hope your drive-in was a titch easier than mine. New Hampshire weather keeps it interesting. As a freshman representative serving on Education Committee, I have considerable respect for your commitment and work. I am Representative Hope Damon, serving the citizens of Sullivan District 8, which includes the beautiful towns of Ackworth, Langdon, Leominster, Goshen, Washington, Springfield, Sunapee, my hometown of Croydon, and the rising city of Claremont. And yes, I share representation of District 8 with your criminal justice colleague, Representative Stone. I am sponsoring House Bill 643 to legalize marijuana for persons 21 and over on behalf of many constituents. I acknowledge that there are several other pending marijuana bills with different approaches to be considered. Prior to being elected representative, I enjoyed a rewarding 40-year career as a private practice dietitian, diabetes educator, and eating disorder specialist. That work means my decision-making is grounded in evidence-based science. I note that because I have come to support and now promote marijuana legislation very thoughtfully. I care deeply about how people take care of themselves. I have great respect for individual freedoms. That background and those values lead me to say New Hampshire is very overdue to legalize marijuana. Prohibition doesn't work. People are utilizing recreational marijuana anyway, and we are way behind all the other New England states in making it safer by regulating the products that are available and in generating revenue for other purposes from sales of marijuana. So this bill sets up retail sales solely through the state of New Hampshire with operations and regulations similar to alcohol and handled by the Liquor Commission. The state would be reimbursed for all costs involved in setting up the retail sales by 2027. After that, 50% of the revenues would be provided to the Education Trust Fund. Funds would be dispersed to municipalities with the lowest total valuation per pupil, and the calculation is defined in the bill. Funds shall be dispersed in ascending order until exhausted. It is well known that the state of New Hampshire does not equitably and adequately fund education. As I'm serving on Education Committee, I am really closely seeing the challenges and adverse effects on our schools, our students, and our taxpayers. The other 50% of marijuana revenues, should this bill pass, would go to a new fund at the Department of Health and Human Services for increased access to mental health care. It has been widely publicized, including several very recent tragedies, that New Hampshire does not have an adequate system of providing mental health care services. And I will say in my career as a dietitian, particularly in my work with eating disorders, but also there's a higher incidence of depression and anxiety disorders in people who have diabetes. It was just a constant challenge to find providers for mental health care services. We just simply don't have enough people providing those services, and part of that is a funding issue for that profession. Going back to this bill, there is also a fund that would be set up at Health and Human Services to present a public media campaign, including social media, on safe storage of marijuana, risks to avoid, not driving, pregnancy, people under 21, et cetera. And that campaign would begin before retail sales started. I will acknowledge that the bill is not perfect as written. I'm a freshman legislator and I'm learning on the job and open to feedback and questions. I do believe the effective date needs to be pushed out. It's not realistic. But overall, this is a thorough and responsible approach to legalizing marijuana and benefiting from the revenues. We owe it to the citizens of New Hampshire to stop treating recreational marijuana as a crime. And we owe it to our citizens to benefit from this revenue opportunity to responsibly fund essentially needed public education and mental health services. Thank you for your time and attention.
Representative Rhodes.
Thank you, Mr. Chairman. Thank you for taking my question. I'm looking at the very first page, under 1, and it's D, where it says, I'm sorry, it's E. Cannabis sold in the state shall be tested, labeled, and subject to additional regulations. Can you give me an example of, is the tested part in this for the funding, and what is an additional regulation?
The testing part is in it further down. It's about making sure that the products being sold are what they say that they are.
Okay.
And that's part of what I was referencing when I spoke about safety. Presently, when people purchase marijuana on the black market, which is happening all over the state, they don't know what it is, really. So this is to make it safer in that regard.
Mr. Chairman, if I just may clarify, you said additional regulations. I'm just not sure exactly what you mean by that. It very well could be in here. Honestly, I haven't got to the whole thing, but.
The bill is long.
Yeah.
Honestly, I don't know the answer to that either.
Okay, thank you.
Representative Newell.
Thank you, Mr. Chairman, and thank you for taking my question. My question is the let me put it this way. There's a lot of money that goes into policing cannabis use, possession, sale, that kind of stuff. I'm wondering if the expenditures that are saved in that, so that the money that is not spent on over-policing, you know what I mean, that kind of thing, is that factored into the financials in this?
I don't believe the fiscal note addressed that.
Okay, thank
So
you.
it would be appropriate to evaluate that.
Thank you.
Representative Salig.
Thank you, Representative, for your time and for taking my question. It's actually a follow-up to Representative Newell's question. If this bill were to be passed, and so we would no longer need to put people into jails for marijuana violations, do you have any information about what kind of cost saving that is, or do you know, cumulatively, or if you have any information or ideas about the best way to determine the reduction in costs, which would not just be at the state levels, but also at the county levels?
Thank you for your question. It's clear that we should know the answer to that, and it's not included here.
Thank you for your testimony.
Thank you.
The chair recognizes Heather Marie Brown.
Can you hear me? All right. Good morning. My name is Heather Marie Brown, and I am the Vice Chairman for the Therapeutic Cannabis Medical Oversight Board. This is a board that works with Health and Human Services. It was established legislatively several years ago to oversee public health and safety matters and so forth. I'm here on my own recognizance and to represent the 13,000 plus patients that we have in this state. And I can tell you from a personal level that although I am extremely supportive of legalizing cannabis in the state of New Hampshire, I do not necessarily agree that this bill is the way to do that. I have a couple of issues with the bill, and those issues would be on, as introduced, page 1, line 14, all retail cannabis stores shall be operated by the state of New Hampshire. I have not seen a state where legalization has come forward, where they have had a successful cannabis program controlled and run by the state in such a fashion as a potential liquor store model. It hasn't worked. I believe that if legalization comes to the state of New Hampshire, that it should be open to New Hampshire residents and to promote small business growth and development within the citizens, not to create a monopoly-like structure for the state of New Hampshire. I also have another issue on page 3, line 23. It says cannabis products containing THC purchased from a retail cannabis store which shall be limited to therapeutic use only, for which the purchaser presents documentation permitting use of cannabis for therapeutic purposes. This bill, basically, what this is saying is that these monopolized stores controlled by the state of New Hampshire can potentially poach therapeutic cannabis patients and provide a detrimental effect to the therapeutic cannabis program. That should not be allowed. Adult use should be exactly that. Adult use, therapeutic should be exactly that, therapeutic use. The two of them should not intermingle in any way, shape, or form. I think it's inappropriate for that to be in there or to even be considered. We don't want to create a problem within the therapeutic cannabis program because regardless of adult use, and now it's not a question of whether or not it will happen, it's a question of when it will happen. And we still will need a therapeutic cannabis program intact, running, and operated because that program provides the information, the research, and the resources that patients need in order to create a proper treatment regimen for themselves in their health and wellness. This bill, there is nothing in this bill that says any of the people working for these stores are going to have the education, the knowledge, or be able to provide information to therapeutic cannabis patients in the manner of which they receive now through our local dispensaries. So, although I do think this is a good attempt, and although I do support legalization, I do not believe that this bill is the best way to do that. I think that it creates a whole bunch of new problems. I think that those items should be stricken, and I would rather see a much better system come to place in the state of New Hampshire in regards to adult use. I will gladly answer any questions you may have, and I thank you for the opportunity to speak.
Representative Newell.
Clearly we do have a couple of different iterations of similar bills. Do you think that this one can be amended to be appropriate and to satisfy your concerns, or do you think that that we would need a completely different bill?
Well, as many of you may know, there have been several legalization bills that have been presented this session, and I personally find that all of them have their own issues and problems within each particular bill. I hate to say it, but I do believe that if you took all of those bills and you stripped them apart and you took bits and pieces from each bill, you could come up with a very satisfactory structure in order to promote adult use in the state of New Hampshire and not interfere with the therapeutic cannabis program as it is now.
Thank you for your testimony. Anyone else wishing to testify on this bill? There being none, I hereby close the public hearing on HB 643 and open the public hearing on HB 581. And who's introducing it? Are you introducing this bill? Is this your bill? Yeah. And I recognize Representative Santonastaso to introduce his bill.
Thank you, Chairman and members of the Criminal Justice Committee. My name's Representative Santonastaso, representing the towns of Ringe, Dublin, and Jaffrey. And House Bill 581 is a simple bill. It deletes the Controlled Drug Act in New Hampshire and establishes a study committee on the implementation of deleting the Controlled Drug Act. This bill's the ultimate solution to the drug legalization question. All these bills are getting filed that are nitpicking in different ways and stuff. This is where it's going to go, ultimately, just as the 18th Amendment of the United States Constitution was repealed. The 18th Amendment, which prohibited the manufacture, sale, and transportation of intoxicating liquors, is pretty interesting for a couple of reasons. One, at the time, they recognized that they couldn't just prohibit straight up possession. So it wasn't illegal to possess liquor during Prohibition. And the other thing that's interesting is that they actually passed an amendment to the Constitution, because at the time in the 1920s, they actually had respect for the Constitution, and they did things like have Congress declare war and used sound money it's mandated by the Constitution that we use gold. So in order for, in Section 2, I'll just read you the 18th Amendment. So Section 1, after 1 year from the ratification of this article, the manufacture, sale, or transportation of intoxicating liquors within the importation thereof into, or the exportation thereof from the United States and all territories subject to the jurisdiction thereof for beverages purposes is hereby prohibited. And then Section 2, the Congress and the several states shall have the concurrent power to enforce this article by the appropriate legislation. So this suggests that it was illegal for the states and the government to prohibit liquor without actually amending the Constitution. And therefore, all the controlled substance acts, New Hampshire's included, are illegal. All right, so private property is natural to man. Laws that prohibit possession of certain items such as drugs or firearms are an infringement on an individual's right to own and use their property as they see fit. As long as an individual is not harming others or causing disturbance, they should be able to possess whatever they choose on their own property without government interference. Criminalizing possession leads to the over-criminalization of society. People who are not committing any harm end up getting labeled as criminals and face the consequences that come with the label, such as fines, imprisonment, criminal record, which have severe and life-lasting impact on them. And then some of these prohibited substances in the Controlled Act, like DMT, for example, have an enormous tradition of religious use longer than the United States even existed. And just having this in statute is completely in violation of the New Hampshire Constitution, Part 1, Article 5. Additionally, these laws disproportionately affect marginalized communities. Some even argue that the purpose of drug war was intentionally to control minority communities. But it is known that individuals from low income and minority groups are disproportionately targeted and arrested for drug possession, despite similar usage rates across different groups. And anecdotally, a group that I'm very familiar with was the 82nd Airborne Division, which was definitely the highest drug use I've ever seen anywhere. It was so rampant, it was just in my face all the time. I was a medic in the Army, so I got a lot of practice doing IVs in the barracks, and there was no questions asked when my aid bag needed to be replenished. It's just known. But America won't enforce these drug laws on their own troops. There's no enforcement because they'd have to face the embarrassment of drug-addicted troops and the hypocrisy of a government that knows this situation but instead sends SWAT teams into regular Americans' homes to compensate drugs. On Prohibition, Somebody asked me to bring up this quote from H.L. Mencken. So, 5 years of prohibition have had at least this one benign effect. They have completely disposed of all the favorite arguments of the prohibitionists. None of the great boons and usufructs that were to follow the passage of the 18th Amendment have come to pass. There is not less drunkenness in the Republic, but more. There's not less crime, but more. Not less insanity, but more. The cost of government is not smaller, but vastly greater. And respect for the law has not increased, but diminished. And that is true. I feel like the respect for law in this country is greatly diminished because of these arbitrary drug laws and the arbitrary enforcement of them. So there's tons and tons of arguments against prohibition, and just, some of them, like when drugs are legal, police resources can be reduced and used towards combating real crimes like theft, assault, and murder. I believe it's the reason why police are against changes like this is because, it's going to reduce the resources that are needed for that kind of thing. So today the police are militarized to fight this war on drugs. The actual .357 revolver cartridge was developed so the police could fight gangsters in the 1920s because now they were using body armor and car doors and stuff like this for cover instead of the .38. So, and that was in the 20s. Now, Keene, New Hampshire has what the city calls a ballistic engineered armored response counterattack truck, but most people just call it a tank. So, also, it would reduce the harm associated with drugs. Okay, so the criminalization of drugs doesn't do anything to stop the sale and distribution of drugs. It just pushes this market underground, leading drugs to be adulterated and contaminated with other harmful substances. All right, so deleting 318B, which this bill does, will make the drug sales more transparent to the end user. It reduced the number of people in prison. So legalization of drugs will decrease the number of people being sent to prison for drug offenses, reducing the strain on the prison system, and reducing the number of people who would be barred from life from certain opportunities because of their criminal record. I urge the committee to take, very simple, common sense approach to this problem by deleting the Controlled Drug Act and making an OTP motion on this bill. All right, and I'll take any questions.
Representative Bolden.
Thank you, Mr. Chairman. Thank you for taking my question. I understand that the Chapter 318B includes RSAs that give New Hampshire entities the ability, the sort of like legal coverage to engage in activities that violate federal law. For example, naloxone being an over-the-counter product in New Hampshire, which is sort of in conflict with FDA standards and DEA standards for naloxone. That's in 318B. The syringe program is part of 318B. Is it your intent to repeal laws that we have in New Hampshire that give legal shelter to people trying to engage in harm reduction?
Yeah, so like 318B is extensive. It covers a lot of things like what you're talking about. So this bill, it goes into effect in 2025 and also establishes a study committee so we can make legislation to move that kind of stuff in other places.
Yes, follow-up.
Thank you for taking my follow-up question. So is it your understanding or expectation that after the repeal and before the passage of new legislation, that for a period of time, it wouldn't be possible for harm reduction efforts in New Hampshire to operate with that legal cover?
So, in matter of priorities, if it comes to using government resources for harm reduction, that would be preferable to using them for criminalization. So, if that was the compromise, then I would be for using government for harm reduction.
Representative Murphy.
Thank you, Mr. Chair, and thank you for taking my question. Actually, you probably just did answer this a little bit, but you had said that this passage of this bill would reduce harm. And I just wondered if you could explain a little bit more how that would reduce harm. Thank you.
Well, for one, drugs are cut with other substances because it's, this market's unregulated. There's no one to check. There's no way to know, right? Especially if you're just an end user. And then, like, the drugs are like supercharged. They find out ways to make them more powerful than they were otherwise because they're prohibited when you're transporting them or anything like this. You want to transport more like potent drugs instead of something. You don't need a car full of something that's not as potent, because if it's illegal, you have to densify it, if you will. So that's some of the things that increase harm. Besides that, just, the criminalization of it makes it, so that there's no legal recourse in the way most business is done. So people have to resort to violence and things like this to conduct their business. Thanks.
Representative Newman.
Yeah, I just have a question about line 1 in this bill that says, repeal RSA 318B relative to the Controlled Drug Act is repealed. So what happens when this bill gets passed? Is that automatically repealed by the passage of the government, if the governor were to sign this? And what date would that be effective?
Yeah, that's correct. So if this passes, the drug 318B isn't deleted immediately, but it will be July 1st, 2025. And so it does that. Mm-hmm.
Thank you.
Representative Reed.
Thank you for taking my question. If this bill, if the Controlled Drug Act is repealed, what would that look like? Would you go to the grocery, would it be, can you just go and buy any of these controlled substances from your pharmacist? What would it look like? Thank you.
Yeah, so we'd expect that dangerous substances like, hard drugs and stuff like this, they would be illegal. You could sell them to the public, but it would be not publicly popular to sell these things to children, and we feel like the market would regulate that kind of thing and not put it in places where it would be inappropriate.
Thank you.
Representative Pratt.
Is this similar to what they did in Oregon?
Sorry, I didn't hear you. Say that again, please.
Is this similar to what they did in Oregon State? Oregon State legalized or decriminalized all drugs. Is this what this is?
I'm sorry, I can't hear you.
Is this the same as decriminalizing drugs as they did in Oregon State?
This just deletes 318B. So it would make it like lots of things that it's just not regulated at all.
Representative.
Apologize, Mr. Chair, I didn't hear the end of that. My question would be, when we're talking about establishing a committee, it talks about to study the statutory and policy changes to state law necessary to implement the repeal. My concern is about the regulation. I mean, you literally just said no regulation. You also had mentioned, the things that are put into other drugs and things will be mixed in and people don't know exactly what's in there. And so my question is, would the committee be also, would what the committee is studying include testing and analyzing and labeling so that people actually do know what is in their drugs and regulation in that way?
You're asking how we would know that the drugs are clean or whatever without regulation?
Yes.
Yeah, so the market would regulate that just like ISO 9001, the way they regulate industry and all these other organizations. There would be, independent organizations that would vouch that, they would check out these guys producing this drug, and they would put out a report that says they're legit. Just the way a lot of things are regulated in the market. So in the way the government would do it, except we don't need to extort the public to have these checks. We can just let the market do it, and there'd be demand for that kind of thing.
Thank you for your testimony this morning, Representative.
Thank you.
The chair recognizes Ms. Bonnie Freeman of the Shire Free Church.
Hello, my name is Bonnie Freeman. I just wanted to come and support this bill. Terence McKenna wrote that untrammeled rationalism, male dominance, and attention to the visible surface of things had rendered society very, very sick. As a progressive who believes humans were put on this earth to evolve and create a better and better world for us to live in, I believe that the government's hindering of human beings exploring their own consciousness, which humans calling themselves government have no right to do in the first place, is not only evil, but holding human beings back from our potential. Exploring different states of mind helps people to grow and their perspectives to change. I agree with McKenna that our society today is very sick, and even sicker now than it was when he died in the year 2000. As of 2016, 2.3 million people were incarcerated in the United States at a rate of 698 people per 100,000. That doesn't sound like a very, it sounds like a sick society to me. And it's honestly barbaric. The fact that most of those people, not most of those people, but any of those people are in prison for utilizing their right to put whatever they want into their body, and it is a right because they're not doing anything wrong to anyone else, is disgusting to me. And no matter what you guys decide today, you won't be able to stop everyone in New Hampshire from putting whatever substances they want into their body anyways. And that's all.
Thank you for sharing with us this morning. Is there anyone else who has not testified on this bill that wishes to? The chair recognizes Mr. Ian Freeman.
Good morning. Thank you for listening today on this very important piece of legislation. I understand that for decades now we've been arguing over nibbling around the edges of the war on drugs, talking about ending prohibition of cannabis. That alone has been controversial. I expect this one will be quite controversial as well. But the reality is, and I don't think there's any controversy, that the war on drugs has failed. It has been failing from the very beginning. It has cost trillions of dollars. It has cost thousands, if not hundreds of thousands, of ruined lives. Millions of people have been put behind bars who have never harmed another human being. They simply took a substance into their body to change their state. It has never worked. Prohibition has never succeeded. All it has succeeded in doing, as Mr. Santonastasso pointed out, is creating a black market and making the drugs even more dangerous than they have ever been. Now, this isn't your fault. This was done before you guys came into office. It was done decades ago, and it was done under dishonesty and lies to make this war on drugs happen. It doesn't work. And we've seen people who are in the business of fighting this war who've said that. There was recently a DEA agent who was arrested for corruption, of course, and before he went to prison, he spilled the beans. He said that everyone in the DEA knows that the war on drugs is a failure. They know it. They know they can't win this war. It's impossible. And that's because supply and demand cannot be defeated. As long as there's someone out there who wants to use drugs, there will be someone who's willing to flaunt the law to make the insane profits that they're able to make because of the war on drugs. That's where the money gets good. Because it's illegal to sell these products, it becomes worth a lot more. So we would likely see the prices of drugs come down. We would see the quality of the drugs go up. We wouldn't see adulterants being added to these drugs, which means that you would see fewer overdose deaths. We know there's a problem with heroin. We know there's a problem with a lot of drugs, people being abusing these drugs. That's not a crime. It shouldn't be a crime to have a medical problem, an addiction. And throwing someone into a prison cell doesn't help them with that addiction. So if we really do care about drug users, and that is purportedly the reason why the war on drugs exists, is to supposedly help people, then if we really cared about them, we would pass this bill and end the war on drugs and lead the way in the United States to do that, because then those people would actually be able to get the help that they need. We've seen it in places like Portugal, which has had decriminalization of all drugs for a very long time, for about 2 decades. People aren't afraid to go and get help, whereas now they're afraid because they think they're going to get turned in and they'll have to go to prison. So if we really care about people, this is the way to go. Yes, people are going to do drugs irresponsibly. They already do that. It's already illegal to get behind the wheel of a car and drive under the influence. That is not being repealed here. DUI would still be a crime. So this just looks at reality and it says, we're going to admit here in New Hampshire that the war on drugs has failed. We can admit our failure and try to make it right. Thank you. Happy to take questions.
Representative Prue.
So you did talk about people getting addicted and it's not their fault and they shouldn't go to prison. But if we repeal all this, and correct me if I'm wrong, it would make it a lot easier for a larger number of people to get addicted because it would be handed to them pretty much. Is that correct? Or am
I don't
wrong?
know if it would really be that easy. I mean, anybody that wants drugs can get them. It's, you just have to know the right people. You can get them online now, too.
Yeah.
I don't
And
think that
makes
threatening
okay.
those people with jail
I'm
is
done.
going to stop them. It hasn't.
Thank you for your testimony. There being no further testimony on the bill, I hereby close the public hearing on HB 581, and the committee will be in recess until 12:45.
for House Bill 473, relative to penalties for controlled drug violations. And, oh boy. Well, I was looking for Representative Roy, but he's not here. Representative, I'm going to slaughter your last name. Could you help me out? I think he's on here, right? Wait, okay, so, hold on, I was.
Assigned for next bill 360.
My apologies, we're working on, okay, so is there somebody here, is there a co-sponsor here for Senate, for House Bill 473? Okay.
Good afternoon, Madam Chair. I'm here to introduce House Bill 473 FN relative to the penalties of controlled drug violations. And I'm sure there's people behind me that can explain this better than I can.
Thank you, Representative. All right, who's first? Okay, I can read Jonathan, and I apologize, but I cannot read this last name. All right, you're up. If you could identify yourself, that'd be great.
There we go. I have a couple handouts. Would you like me to bring those up right now? Okay. The handouts, one is going to be my written testimony. The other is going to be detailing the schedule or the drug schedule.
Representative, if you could just please identify yourself before you.
Yes, sir.
Actually, you might not be representative, my bad.
Yes, ma'am. My name is Jonathan Duchesne. Thank you for allowing me to speak on behalf of the Manchester Police Department and Chief Alderberg in opposition of House Bill 473-FN. I work for the Manchester Police Department as a detective in the Special Enforcement Division. I've been a police officer for nearly 20 years and within my current role for the past 8 years. I am also a lifelong resident of the state of New Hampshire. As a detective working in the Special Enforcement Division, my primary function is to identify problem locations and subjects who are responsible for the possession, distribution of illegal narcotics within the city. In addition to identifying these sources, I, along with other members of the detectives assigned to the Special Enforcement Division, conduct routine drug interdiction stops, arrests and search warrants, and arrest warrants. We also cultivate informants who in turn further investigations to locate the source of these illegal narcotics and conduct long-term investigations. When I started as a detective working narcotics in Manchester in 2015, it was at the beginning of the opioid epidemic in the United States. Manchester gained national recognition, not in a positive way, during this era, as U.S. News and World Report listed in a June 2017 article identifying New Hampshire as, quote, ground zero for the opioid crisis, further listing that in 2015, 2/3 of the state's drug deaths resulted from fentanyl. In 2016, ABC News also dedicated a 2020 episode with David Muir, who came to New Hampshire and Manchester, highlighting the current crisis within the state. I've been on countless arrests, seizures of all kinds of drugs, to include but not limited to heroin, fentanyl, cocaine, crack cocaine, crystal meth, and prescription drugs. During these investigations, it is becoming more and more common that these seizures are tied to violent crimes and deadly weapons. Many of our investigations originate from someone who commits a crime who is willing to provide information in exchange for consideration on their charge. In turn, we are able to expand and branch out our investigations. When I was made aware of House Bill 473-FN, it concerned me greatly, as I know the negative effect it will have on our state and local communities. House Bill 473-FN is seeking to reduce the penalty for Schedule 1 through 4 narcotics from a Class B felony to a misdemeanor for offenses. This will inherently cripple New Hampshire law enforcement in our role of enforcing prevention of serious narcotics, as those people who would normally be willing to provide information will no longer do so, as there will be little deterrence. We need to look no further than the state of Oregon, which in 2020 chose a similar path in decriminalizing serious narcotics. An Associated Press article from 2021 outlined since decriminalization, Oregon saw an increase of 20% in overdose deaths. With a budget of $302 million in facilities used for treatment, furthermore, out of the 16,000 people who accessed services for the first year of the decriminalization, only 0.85% entered treatment, so less than 1%. Given my years of experience as a police officer and as a detective in the narcotics unit, the knowledge I've gained supports that these illegal drugs, specifically those designated Schedule 1 through 4, have a ripple effect caused by their trafficking and use. I have seen firsthand that these drugs have an addiction rate that is linked to other crimes that occur, such as but not limited to burglaries, thefts, assaults, violent crimes, etc. And more often than not are the driving factor behind these offenses. In closing, it is my opinion, supported by years of being on the front lines in this epidemic, that House Bill 473-FN will have an adverse effect more than its intended purpose. I ask that you find this bill inexpedient to legislate. I thank you again for your time and consideration in this matter. Respectfully, Detective Jonathan Duchesne, Manchester Police Department, Special Enforcement Division.
Thank you, Detective. Are there any questions from the committee?
Yes, ma'am.
Representative Knoll?
Thank you, and thank you for taking my question. You talked about, Manchester being ground zero, New Hampshire being ground zero. I'm very familiar with the overdose crisis. I actually lost my children's father and fiance at the time 14 years ago, Christmas Eve, to overdose. So it's been a little over 14 years. And over those 14 years, I've seen prevention enforcement through the criminal justice system, not only in his case, but also, just over time, increase, and yet the problem has gotten worse. And I'm just curious, more people die all the time. And so I wonder how you feel about this approach and how successful it is.
Well, first off, I'm very sorry for your loss. What I can say, given my experience, is if we reduce the penalty on this, there's going to be a floodgate of the drugs entering in the state even more so than there already is. And it's going to make our job almost impossible to do, to try and go after the suppliers and go after the people that are essentially distributing poison out on our streets. And that's why I'm here today, and that's why I'm very concerned with this bill.
You recognize for follow-up question?
Thank you, and I mean no disrespect. I'm not trying to criticize at all. I fully believe that that the intention here is very pure and good. My question is, the follow-up is one of the issues that you cited is the fact that fentanyl and now other drugs are being found in substances, and they are much more powerful and harmful. And I'm wondering, do you think it would make your job easier and be helpful to people who are struggling with it to know what's in their drugs and know what's in their supply? I guess that's the essential question.
What I can say is, given my experience, people that do have an addiction or people that are dealing, unfortunately, really pay no attention to the potency in the drug. More or less, they're looking for the most potent drug that is out there to give them a better high out there on the street. That's been my experience, in specifically dealing with fentanyl.
Thank you, I appreciate you.
Thank you.
Representative Sitek?
Hi, Detective. The question I have is this. A misdemeanor A carries a year in jail, so the potential of that. What I'm wondering about, which is significant for somebody that's using, not selling. Where I'm going is this. Do you have, or does anyone have any real statistics on just how Superior Court sentences people? Are they getting anything more than a year? Wouldn't the misdemeanor do the same, aggressive enforcement of misdemeanor do the same thing? How are felony Bs, special felonies, what is their outcome typically? Do you see the area that I'm interested in?
Yes, sir. I hope I can try and answer your question to the best of my ability. It's been my experience, especially dealing with serious narcotics such as fentanyl, crystal methamphetamine. Those are the driving factor. Unfortunately, what is taking place on the streets in Manchester right now. And a lot of times those narcotics are kind of go hand in hand with people that carry weapons and commit violent crimes. And I'm sure many have seen in the news a lot lately that their violent crimes do take place in Manchester more than we would hope for or would want. So there's definitely that factor tied to these illegal drugs.
Representative Wheeler?
Thank you, Madam Chair. I appreciate your concern about people and their addictions to opioids. I'm wondering, do you think throwing someone in prison would aid or ail their addiction?
Chief Aldenberg is also here from the Manchester Police Department.
For the record, I'm Chief Alan Aldenberg, Chief of Police of the Manchester Police Department. So, Representative, you're asking, being in or out, what would help their addiction most? Like, is that what you're saying?
Well, would being in prison aid their addiction, essentially? Would someone who's not selling and has been addicted to drugs, would throwing them in prison
Well, I mean,
help
in
their
theory, if somebody's in prison, they shouldn't have access to drugs, right? But are there drugs in the in the correction system? Yes, there are, but not to the level that are on the streets. So I'm kind of, is that your point? Is that? Yeah, I just want to make sure I got it right.
No, absolutely, and I more wondering about the environment in prison. If someone is on the streets addicted to drugs and that homeless person is arrested, and would having them be in prison be conducive to them getting off the addiction?
Well, certainly if somebody's addicted to drugs and they're still remaining on the street, their ability to remain addicted is exponentially more if they were in a prison or in a jail. So I hope I'm answering your question there. So are people that are, people are not being detained for drug offenses. Majority of them, and I'm sure there's others in the room that may disagree, but people are being arrested for first offense, third offense, fifth offense for drug possession or drug distribution, and are being released over and over and over. And that's not helping the addiction problem. That's not helping what we're dealing with. Is putting people in prison the answer to this problem? I wouldn't advocate that. I think that, along the lines of treatment, intervention, education, whatever we can do along those lines is just as important as the enforcement angle. Right? We are not going to enforce our way out of this problem. Are we going to get our way out of this problem by putting everybody in a jail and a prison? No, I don't. Are people more apt to get the treatment perhaps that they need inside a facility and get into a program that's more structured, where we have their attention? I would say there's an argument in favor of that. I'm glad to have a conversation with you after, sir. Absolutely.
Representative Newman?
I have a question that's a little, maybe along the same lines. It looks like from my reading of the bill that the current punishment is a Class B felony. And then the bill reduces it to a misdemeanor for the first offense. And the other punishment is Class A going to a Class B felony. Since the Class A misdemeanor has the possibility of a year in jail, why would that be an improvement to the bill rather than going all the way to a Class B felony, which is 3 to 7 years? And there may be something in there in the court process where one or the other gets prosecuted more often or leads the way to maybe coming up with a plea deal or something like that. I'm just wondering why go all the way to just why not? Would it be help as if it was a Class A misdemeanor?
You're saying that, in your opinion, if somebody's convicted of first offense, misdemeanor Class A, that they're going to get that year in jail? I'm pretty confident that they're not going to get that year in jail. That's the reality of our court system right now. I have people that are committing crimes over and over and over and are not getting the appropriate sentence that they should. That's not my doing or my decision. We put forward cases, but unfortunately what we live in now is that people aren't getting the appropriate sentences in some cases that they deserve. And that's why we have these repeat offenders. To the detective's point, if you make these misdemeanor level offenses, these drug organizations, these cartel level organizations are going to flood this state, okay, because they are more than they already do, because they know that they are now operating in a state with a penalty for spreading this poison in our state and killing people. For those that are in possession of it, they are going to have minimal to no ramifications. I would be very, very confident saying that people on a first offense, that becomes a misdemeanor level conviction, they're not going to go to jail. I just know from experience. I know from how my court operates, how Hillsborough County operates. They may go into drug court. Okay, if drug court was an effective mechanism right now, I can speak and tell you that it's not. If drug court was better and operating more efficiently, then maybe that's a better option for those people to have that first offense, felony, or misdemeanor.
Thank you.
Representative Sytek?
I'd like to thank you for appearing, Chief. I want to follow up on what I had asked before. You said very few misdemeanors get actual jail time. That's the way our court system is. I understand that. Earlier today I said I'm a bail commissioner. I kind of have an idea of what you're talking about. My question is this. What happens in a felony conviction, Class B felony conviction? What is the likely sentence in your experience?
First offense?
First offense, yes.
Depends on a lot of things go into play there, the person's overall criminal record. If you take a case where it's a first offense, Class A, and they have no other criminal record, I would say that the likelihood of them going to prison is probably relatively low. They're probably looking at some type of extensive probation, drug court, some other residential program as part of a plea deal. But there's a lot of variables that go into determining somebody's sentence when it gets to a judge, as you all know.
Seeing no further questions, thank you.
We appreciate your time. Thank you.
Representative Roy?
Thank you for taking my testimony. I'm Representative Kerry Roy, representing Rockingham District 31, towns of Deerfield, Candia, Auburn, and Chester. I have to get that right. They changed with the redistricting. I apologize for not being here for the opening of this. Unfortunately, I realized that having the chair position, everybody wants to talk to you, and I got waylaid 6 times on the way back here. So with regard to this bill, I understand law enforcement's position, and I agree with them a lot, that it's a valuable tool to have in your arsenal to be able to charge someone with a felony on the first offense. I disagree with them in that's how we should be operating our justice system. We should not be creating felons, in my opinion, out of so many people for a first offense on this. That the drug crime has not gone down with the felonies. It stays the same. It seems to really not matter what it is. But what does happen is we've created a whole bunch of people that we're putting out of the labor pool. When you have a felony conviction, there's a whole slew of jobs you cannot get. And it does, we can discuss the whys and hows, but it does disproportionately affect minority communities. And these are the people who have the lowest unemployment rates to begin with, the highest unemployment rates, excuse me. I think that we need to look at a different way to do this, a different way of interdicting drugs. We need to give the police the tools they need to stop the drugs coming into our communities more than punishing the people who get caught with the first offense amount. And let's be clear as far as what that means. You're still, if the amount is correct, you're still going to get charged with possession intent or with distribution or with drug kingpin, depending on the amount of drugs you have. We're talking about simple possession. Now, I believe we need to tweak the amounts on certain things, like fentanyl should be much smaller. But the other drugs, you're talking about a personal use amount of drugs. Not enough to sell, not enough to distribute, personal use. And there's a big difference, in my opinion, someone who's using, they're hurting themselves, but they're not distributing. And a misdemeanor crime conviction is no small thing. There are penalties, there's jail time possibility, there's financial possibilities. It's still a very serious thing to happen to somebody. So I would ask the committee to consider and weigh how the current system's working, if it's working, and if it's not, is there a greater benefit in producing less felons and making people have a chance to go forward in society and improve their lives, or tagging them as felons and limiting the amount of work and future opportunities in their life, which already sets them down a path of hopelessness. So that's my testimony. I'd be happy to take questions.
Representative Janvin?
Thank you to the Vice Chair, and thank you for taking my question. I noticed that on the first offense, you're proposing to change the Class B felony to a misdemeanor. And my question to you is this. Misdemeanor A is potential of jail time and the right to counsel. Misdemeanor B has no right to counsel and is fine only. Would you agree, would you have any thoughts on whether it should be a misdemeanor A or B, and why did you choose just misdemeanor?
If I heard you correctly, whether or not I would be open to either level of misdemeanor, and possibly because it doesn't give a right to counsel, is that correct?
Yeah, a misdemeanor A affords you the right to counsel, a misdemeanor B does not.
Agreed, but I don't think that charging someone with a higher level offense just so they can get right to counsel is probably a good policy. I'm not sure, understandably, that they need counsel regardless of the level, but I don't think that we can solve that by charging up just so they get counsel. I would worry about that. But as to whether or not the penalty is appropriate, that's something that we can discuss, and I'd be happy to discuss with everyone when we're debating this issue in executive session.
No? Seeing no further questions, thank you, Representative Roy.
Thank you.
Dan Hines? Oh, Representative, I'm sorry.
Yeah, that's okay, I didn't write it.
I don't think it's on here in my defense.
Yeah, I will fix that feature. Thank you, Dan Hines, representing Hillsborough 2, Town of Bedford, and obviously support this bill. And I don't want to be redundant, but I think people are in agreement, and a lot of people ask, well, what's the penalty for this? So by way of background, I'm a criminal defense lawyer, have handled drug possession cases over the years. And so unfortunately, it's not very consistent, in my opinion, throughout the state. So many county attorneys will routinely drop these down to misdemeanors, but others will not. At the end of the day, if someone has a simple possession of cocaine, fat, heroin, any of these felony type drugs, they have no criminal record, nothing else, I don't see, even if they went to jury trial and were found guilty, I do not see a judge sentencing that person to prison. Routinely, people get, in my experience, I think if there's nothing else, people get house of correction time, which is jail, which can only be up to 12 months, which would make it a misdemeanor level penalty. And oftentimes, that's all suspended if it were a plea. Often there's conditions with that, so it could be be on probation, or it could be drug counseling, things to that effect. But at the end of the day, people are not going to prison for first offense possession charges unless they were sentenced on something else like theft or something like that. All this is doing with making it a felony is making them have a felon criminal record. What that is doing is preventing them from obtaining employment in the future. I think personally the best way to address the drug problem is rehabilitation. I think people who use drugs fall into two classes, people who are addicted to it and people who recreationally use it. For both of those people, I think rehabilitation is still the best approach, but punishment just does not work. People are not being sent to prison for up to 7 years on these types of charges, so it's already not happening. I think the position that this would invite drug cartels to the state is borderline absurd. I certainly don't think it will happen because this is only applying to people possessing. It's not applying to people distributing. Drug cartels cannot come in, if this bill were to take law, and say, here, sell some drugs. You'll only have a misdemeanor. Not going to happen. There's still going to be facing felony selling or distribution penalties. I do not think anyone who goes out seeking for drugs in the back of their mind goes, well, I don't want to do that. It's a felony. But, it's a misdemeanor. Let me have some of that drugs. It just doesn't happen like that. In regards to the difference for Representative Jambrin's question, A versus B, the reason I would support it being not defined is most of our criminal code doesn't define things. There are a few exceptions. So DWI first offense is a class B, the reason being, as you point out, people don't get counsel. Some charges are specifically A, particularly if they have a penalty associated with it with mandatory jail time, they would have to be. But I think leaving it just a blank misdemeanor leaves the prosecution discretion to bring it as an A or B, which I think makes sense. I don't think all drug charges are the same. So there's a difference between someone who has, I guess, just a small amount of cocaine or heroin, and that's it, versus someone who is doing that, committing thefts, all types of other things. So I think it should be up to the prosecutor whether to bring it as an A or B in that regard. I think that's everything. I'm happy to take any questions.
Representative Jandrin?
Thank you, and it's unique that you're an attorney that defends cases in this matter. So my question to you would be, on average, how many of these cases that are covered by this bill are actually deferred to the drug court?
So I don't know the answer to that. I know we've been expanding the drug courts over the years, and I'm certainly supportive of that. I do think that is one of the best ways to go about addressing this issue. And I don't know if there's a uniform policy throughout drug courts and counties of what happens after the fact, but they do it a little differently. So, or I'm not sure if they all do it exactly the same as well. But there are cases that just don't go to drug court, so they do have, I guess, typically requirements to get into that court. So if this fell outside of that, I think it's appropriate then for those offenses to be misdemeanors.
See no further questions. Thank you.
Thank you.
Frank Knack?
Madam Chair, members of the committee, thank you so much for the opportunity to testify. My name is Frank Knack. I'm the Policy Director with the ACLU of New Hampshire, and we are here in strong support of HB 473. So I want to talk at first about a couple of issues. I think one, we heard a little bit about the need to have prison as a punishment, and just to give some economics here, it costs about $64,000 a year to incarcerate someone in our prison. It's substantially cheaper to actually engage in evidence-based harm reduction programs at the local level. Unfortunately, there are multiple bills before this committee and this body this session around access to drug testing kits. We already have naloxone. Those are proven evidence-based strategies if we really care about saving lives and reducing harm in our communities. I think it's also really important to point out, when we think about drug arrests, we think about, we are going after dealers, and that is just fundamentally not the case here in New Hampshire. So again, in the fact sheet I handed out, we have the data to show you. We looked at FBI UCR data reports that our state agencies provide to the FBI. And out of the 3,592 drug arrests in 2021 in New Hampshire, 87%, so 3,150, were for mere possession. So the vast majority of arrests happening in our state right now are for possession level offenses. And that possession level disparity has actually increased. So over the 10-year period, it was 80%. So we're actually going in the wrong direction. We're arresting more people for simple possession and not for distribution. We also heard a little bit about the enormous collateral consequences that attach to a felony conviction, and I just quickly looked up. So we have, all types of collateral consequences under our law. Some are mandatory, some are discretionary, some are by defense type. So I just pulled mandatory misdemeanor and mandatory felony. So for mandatory felony collateral consequences under New Hampshire law that apply to all aspects, from education to housing to employment, there are 335 various collateral consequences that attach to every felony conviction in New Hampshire. For a misdemeanor, it's still extremely high at 99, but substantially fewer. And so this notion that, going from a felony to a misdemeanor we're only talking about first-time possession here. We're talking about one narrow type of arrest here. It's still substantial. As we heard, a year potentially in jail, 99 mandatory collateral consequences that'll attach to that person. So it's still substantial. And there's also a huge racial disparity that I think is really important to point out. So Black people in New Hampshire make up about 1.8% of our population, yet make up 6.5% of all drug arrests. So a staggering racial disparity in our drug arrests. And so this legislation will have a really positive impact on beginning to address those harms. And I think finally, we heard this earlier today from one testifier, and we also heard this a lot last year in this bill, which made it through the House last year and over to the Senate. We heard a lot about we need to have harsh punishments because harsh punishments are what work. And so, we are now in our 52nd year, I think, of the war on drugs. It started back in 1971. And I think one thing is crystal clear. The notion that we can arrest our way out of drug use is not supported by reality, but yet we continue to go down that path. And so I just want to, one of the reports I cite in here is from Pew Charitable Trust, well-respected national organization that does research. And I'll just read what they said. So they looked at available data from federal and state law enforcement, corrections, and health agencies, and their analysis found no statistically significant relationship between state drug imprisonment rates and 3 indicators of state drug problems: self-reported drug use, drug overdose deaths, and drug arrests. The findings reinforce a large body of prior research that casts doubt on the theory that stiffer prison terms deter drug misuse, distribution, and other drug law violations. The evidence strongly suggests that policymakers should pursue alternative strategies that research show work better and cost less. Happy to answer any questions.
Representative Janfrin.
Thank you to the chair, and thank you for taking my question. I find myself in a very unique position where I represent the people of Hampton, which includes Hampton Beach. And I will tell you that I believe, and I don't know if you have statistics to this effect because you used all of yours from the FBI's UCR, but do you have any idea of how many people that go to our beaches from state to the south that are of minority populations are arrested for drug possession? And second part of that is, do you have any idea how many of those people? Yep. Okay, I'll let you answer that if you have any idea.
I know just state level FBI UCR data, the racial disparities in this case, and also specific to marijuana as well, that I'd be happy to discuss.
And a follow-up.
Can I ask for follow-up?
Thank you for the recognizing for the follow-up. And as a follow-up to that, my question is, how many of these people, if it's quoted in the UCR, are arrested for another offense in addition to possession of drugs that may be a violent crime?
So my understanding is FBI UCR data is primary offense data, and so that is the most serious offense. So it would have to be some lesser offense if there were multiple charges.
Senator Wheeler?
Thank you, Madam Chair. Thank you, Frank, for taking my question. Were the arrests, so out of the 3,592 arrests, drug arrests, were the 3,100 or 3,150 that were for possession, were they just for possession, or were they including possession?
So that was the primary offense. So there may have been other, lesser offenses included, but that was the primary offense.
Thank you.
Seeing no further questions, thank you.
Thank you so much.
Dr. Hannan?
Oh, closer than I thought. Hello, members of the committee. My name is Joe Hannan. I've a pretty extensive background working with the substance use community. I helped start some recovery community organizations, harm reduction groups, syringe exchanges. I was involved in helping with the legislation for syringe service programs, Narcan, naloxone being legalized, and a lot of other different things. I'm also someone who's in long-term recovery for over 32 years now, I guess. And I've had a lot of experience with individuals who have been incarcerated and also people who have experienced the harms of being incarcerated because of their disease. There's a lot of things I could talk about, but I think one of the most blaringly scary statistics that I've ever heard was the dangers of dying of an overdose after being released from incarceration within the first 2 weeks. There was a study in North Carolina at UNC back in 2018. It was published in the Journal of Public Health. They had 5 researchers. They had a member from the North Carolina Department of Public Health and also a member from their Department of Safety involved in the research project. And they monitored the overdose deaths in people that were formerly incarcerated. And within the first 2 weeks, they found that the risk of dying of an overdose in the first 2 weeks of being released was 40 times higher than the general population for all substances. When looking at heroin use only, which would also include fentanyl, that same number jumped to 74 times more likely to die of an overdose after being released. So we're arresting people for their own safety and for public safety, but then when we release them, they're way more likely to die of an overdose after that incarceration. There's other studies that looked at being released, and it can also apply to short-term mental health holds or even short-term rehabs for a week or two in a detox, and then they kick someone out on the street because they can't get into a treatment program. So if someone is not being able to get their substances, which is not completely impossible in jail. I hear countless stories. I know firsthand accounts of people who told me they have no problem getting drugs in jail. Might be a little more of an effort, but it's not a problem for people that really need to do that, really need to get them. But for some that don't, they go through serious withdrawal, they're not getting medical assisted treatment, and they're sick. They feel like they're gonna die. It's one of the most horrible things on the planet you can think of. Some people might say, oh, they deserve it, they were doing drugs. No one deserves to feel like that. And then when they get out, their tolerance may be lower. They might not know what substances they're getting because drugs are not regulated. We don't know what's in something that's on the street. So if someone goes to a different dealer because the person they were with might have got arrested with them, they have to go to a new supplier, they don't know what's in it. They can't go to Consumer Protection and say, that guy didn't give me the same fentanyl I got last time, so they get something that may be stronger or weaker. If it's weaker, they can't complain. If it's stronger, they may overdose and die. When we arrest someone, they're more likely to be unemployed, to lose their job if they had one. And there is a myth that people that do drugs don't have jobs. There was a statistic years ago I was reading that 74% of all people who do heroin have one thing in common, that they either have a full or part-time job. It's hard to believe, but it is true. I do syringe exchange outreach on a weekly basis in the state for about 5-6 years now. And I see people all the time, they pull up or they come on their bicycles, and some people, we try to do it earlier in the day, but we have to do it later at night because people work. There are people that work. But if they get arrested, they lose their job. And I hear this story, I don't think a month goes by where I don't hear someone saying, I had a job, but I got fired because I got arrested. And even if it was for a 2 or 3 day hold over the weekend, even if it was a misdemeanor, if they lose their job, that person is more likely to be unhoused, not only unemployed, but unhoused, and then less likely to be able to have access to treatment or any kind of help whatsoever in the future. When someone's living in a tent in the woods because they lost their job, because they were arrested for their own good, what good is that doing society, and what is the benefit of public health? There is none. So, I mean, I could keep going, but I think you kind of get the gist of it. I'd be happy to answer any questions, and I beg you to please, at the very least, pass this bill. I think it should be more, but this is an excellent start, and I commend everyone for listening and for the people who spoke in favor. Yes, I'm sorry, they call it, yeah.
Representative Knoll.
Sorry.
I thank you, first of all, for taking my question. And thank you for your service to people in New Hampshire dealing with substance use. Sounds like you've done some amazing things in the harm reduction realm, and I appreciate that. I was wondering if, in your vast experience of working with people who are struggling with that, you know, you talked about the increase in the likelihood of overdose death when someone is incarcerated and then they're released. And I'm wondering, you know, I have my own experience that I can put this into, but that's just anecdotal. I'm wondering if, in your experience with a lot more people, how the threat of incarceration impacts people's use.
How the threat of incarceration? Well, the fact that something is illegal in the first place drives drug use, not just underground, but into the shadows. And I mean that not just figuratively, but literally. You know, people will use behind a dumpster in a dark alley, behind a bush somewhere. They're more likely, if they're using injection drugs, they're more likely to have a mistake. They might not hit the vein they're trying to do. It's more dangerous. People with money, you know, I mean, Keith Richards went all those years and he's still alive somehow. Good for him. But, you know, he was able to do it in a nice hotel or in his big mansion somewhere. We don't really think about not having the ability and the means to use safely. And not even just illicit substances. If you are someone who's diabetic and you have to keep doing blood checks and checking your finger sticks all the time and you can't wash your hands, and they're dirty, you're gonna get an infection. You're more likely to have serious issues. And I was a foot and ankle surgeon for many years. I didn't see a lot of people, you know, injecting in their feet, but it was definitely something that happened. And if someone is homeless or unable to bathe on a regular basis, so they don't have you know, hot and cold water or any water, they are gonna lose a limb. I've had to amputate feet and, you know, people below the knee because they had serious infections from shooting up between their toes because they wanted to hide their track marks, or they just ran out of veins somewhere else because they kept having to rush and do something very quickly. So I'm not, you know, I don't necessarily condone someone doing something. People make their own decisions, but I think it's very important we do as much as we can to remove the barriers to dangerous use. It's already one thing to be taking fentanyl or heroin. It's another to have policies in place for decades that make it more dangerous and more harmful to everybody. And it's not just the people that are getting these injuries and these infections and losing their jobs. It's the healthcare workers and the first responders, the police and the EMTs who have to deal with this on a regular basis. A week doesn't go by where I don't see a very serious infection where I have to beg the person to go to the hospital. And it's a very hard conversation to have. They're afraid to go to the hospital, either because of arrest or mistreatment. And it's not most providers give great treatment. My wife was an ER doc for about 30 years. You know, it's very difficult from that perspective even to see that on a day-to-day basis when it can be prevented. We can have safer, more humane policies in place that prevent this tragic loss of health, life, and just threats to public safety in general.
Thank you.
Thank you, Doctor.
Thank you.
Is there anybody that is here that wishes to testify that has not turned in a pink card? Right. See none, we will close the, oh, do you want to testify?
Good afternoon. For the record, my name is Heather Marie Brown. I originally had not planned on testifying on this bill because I do think it is time that we change penalties around how we handle controlled substances in the state of New Hampshire. But I would also like to remind the committee that as of right now, cannabis is still considered a controlled drug and is still classified as a level 1 controlled drug, even in the state. And we do have a decrim program, we do have therapeutic cannabis, and I found it very difficult to determine how this particular bill would possibly impact cannabis in any way, shape, or form. So I would definitely ask the committee to take a long, hard look into that, because I can hear through testimony that the intent of this bill is in relevance to opioids and other narcotics, but it is not expressed in the bill language itself. And at this point in time, no one should be charged with a felony in regards to cannabis for anything, whether they're a patient or they're a personal user or anything like that. So I do agree with the need for change, but I do request that the committee take a long, hard look at how this particular bill could possibly interact or interfere with anything that's in place or will be coming in place in regards to cannabis or the therapeutic cannabis program. Thank you very much.
A question? All right, at this time, we will close the public hearing for House Bill 473.
At this time, I'll open the public hearing on HB 360 and introduce Representative Polizov to introduce the bill.
Mr. Chair, members of committee, my name is Yuri Polozov, representing Merrimack 10, Hooksett Dunbarton. I'm here to present Bill 360 FN, an act legalizing cannabis for persons 21 years of age or older. I believe it's logical next step that we need to take. Previously, we decriminalized certain substances and we introduced medical marijuana, and we saw no negative effects after those steps were introduced. In opposition to this bill, you will see some additional statistics, and I warn you that some of the statistics might be inaccurate. For example, if a state that legalized cannabis does more testing, that it might appear that marijuana can lead to more accidents on the road. But we know that many users of such substances, they tend to stay home or drive slower. So I warn you about those statistics. And as you heard before earlier today, drug war has failed and prohibition has failed, and New Hampshire is selling alcohol in liquor stores, and it's a fact that alcohol is more dangerous substance than what you can find in cannabis. And 2 points why this bill needs to be, why we need it now. We are currently in Merrimack County, and in Merrimack County, we just don't have staff for our jails here, and certain staff shortages you will see in other counties around the state. And currently it's alleviated by, we don't have as many convicts due to bail reform and other circumstances. But as some of the steps of bail reform are about to be reversed, and with current economic recession leading to more crimes, we will just have not enough resources. And the same with police resources. I represent towns that are bordering Manchester, New Hampshire, and you might have heard about crime level in Manchester. And from my experience, I might tell you, speaking with different Manchester residents, it's pretty common that police doesn't have enough resources to investigate property crime when there's an actual victim, when the vehicle was damaged or stolen. And many Manchester residents wouldn't even go to police if their bicycle stolen or something like that, because they know that it won't be properly investigated. And our laws direct police to investigate drug crimes, including people who smoke or sell weed. So as a legislative body, it's up to us to set up priorities straight for police to help them to prioritize investigating when there's an actual victims and property crimes. And last point, you might have heard about marijuana laced with fentanyl. It's something recent. And why it's happening? The only reason why it's happening is because cannabis is not legalized. So when it's illegal, there's no way for buyers to know its quality, to set up some process to verify the legitimacy of a person who they're buying from. So actual lives are on the line because those opiates can kill people, and they do kill people in this country. Thank you.
Representative Selly.
Thank you, Mr. Chair. Thank you for taking my question. So if I understand correctly, this legalizes cannabis completely and has no method in it for verifying that what people have is pure and clean. Is that correct?
Could you repeat the last sentence? No method to verify what?
So I'm just trying to understand, your bill is to completely legalize cannabis, but there's no method for regulating the sale or distribution or ensuring that it's not laced.
Correct, but when it's legal, it's sold through legal stores, and then we have all the safeguards established by free market, but also by customer protection laws and knowing who is your seller.
Thank you for your testimony.
Thank you.
The chair recognizes Dr. Hannan.
Thank you, members of the committee. I want to introduce myself again. It's not been that long. I don't want to speak too long on this. I'd make myself available to answer any questions, but I do like to just mention one or two little things. One, we've heard a lot of testimony in prior cannabis bills and legislation about access for youth. This is obviously for adults. This does not pertain to children, especially, or people under 21 who are also adults. The other thing is that you hear a lot about talks about gateway drugs, and it's one thing leads to another. As someone who has a youthful colorful youth history himself. I can tell you personally and through a lot of experience talking to other individuals and research and different studies out there, that there is a much higher likelihood of someone getting more illicit substances on the illicit market, more dangerous drugs like fentanyl, heroin, methamphetamines, if they're buying something that is already on the illicit market that is a lower level drug, considered a lower dangerous drug like cannabis. So, most teenagers are not going into a liquor store and buying fentanyl. They're not going into a bar. They're not going into a cannabis store in Maine, Vermont, or Massachusetts. They're usually buying it on the street. And if we can get rid of that, we can actually make a giant step in preventing underage use of some of these substances. Be happy to take any questions.
Representative Wheeler.
Sorry, Mr. Chairman, I thank you for letting me take this question. Is it easy to get marijuana at a store in Massachusetts or Vermont, one of the states where it's legal?
I haven't done it, so I don't know personally how easy it is, but I know people just drive across the border, they buy it, and we've heard testimony, and I think yesterday we heard something in Commerce about another bill that was testifying there. I don't trying to talk about this bill, but there were at least one or two people testified about more cars with New Hampshire plates in the parking lot right over the border in Maine and in Massachusetts. And I know that's from people telling me that they've done it to hearing testimony, it's definitely happening. It's not hard to do. I'm trying to find the statistics, but someone told me that most of the New Hampshire population, I forget the percentage, but it's a very large percentage, within 45 minutes of a dispensary in another state. So they're driving there, they're getting it. The other thing is, I've heard a lot of complaints from law enforcement about, we don't have a way to test for it, they're on the roads, they're driving. They're driving now, and they're driving further and longer because they have to go somewhere else to get it because it's not legal here. So if you want to have less people under the influence on the roads, make it local. I mean, if someone has to go and get it, usually responsible people would wait till they get home. I'd like to think that's the rule, but it may not happen. It's more likely to be a problem if people have to go further. Thank you.
Representative Newell.
I'm curious, since you seem to be familiar with the subject, rather than a gateway drug to use of other more serious drugs, one of the things I've been reading about lately is its therapeutic value in helping people struggling with substance use. And I'm curious if you have any knowledge on that and if you could speak to it.
Yes, there's for many decades in this country and around the world, the standard of treatment for substance use was, well, just don't do it. We can't have anybody doing anything. If you're doing it, you're not in recovery. And when I came around in 1991, that was the school of thought. You just don't do it. And I haven't since, but there are a lot of people who, there's a continuum of use from casual to chaotic use. And people fall all along that continuum of usage. If there's a way to get someone from very chaotic use that's very harmful to get it to more moderate or even occasional use, that's infinitely better than not doing anything and staying in chaotic use. And if we force people to just be abstinent all the time, it's a nice goal, but it's not realistic. We live in the real world. And I think that having options available may not be the ideal for everybody, but I think it is an absolute necessity to have it as an option available. Years ago, I was invited to HempFest. And I was like, well, I was a state rep. I think I knew I had like 25 years in recovery. I'm like, I appreciate the offer. I'm okay. I'm in recovery. And he looked at me and goes, so am I. And I'm like, what are you talking about? And he told me, he used to do this and that, cocaine, crack, and he lost his family, all this stuff. And now he has all that back. He smokes pot, smokes cannabis, but he's got all those other things. And that is not just a one-off situation. I've heard countless situations like that. It's not my preferred method of treatment, but if it works for somebody, who am I to say that they're living a better life is not right for them? And it does work for a lot of people.
Thank you for your testimony. Is there anyone else wishing to testify on this bill who has not submitted a card?
If it's all right, I would just like to add a little bit to what he was saying. I will, yes.
And I'll recognize Mr. Freeman.
So yeah, I really appreciate this bill. Thank you all for listening to it. There's obviously a lot of legislation that proposes to change the laws on cannabis. I appreciate the ones that don't involve a bunch of regulations and taxes and hoops and applications and fees. This is a plant. It should be treated like a plant, meaning that the government should stay out of it. Somebody mentioned, one of the reps in their questions mentioned lacing cannabis. As someone who has been involved in the purchase of cannabis over many years, I have never come across anything that would have been advertised or not advertised as laced cannabis. Even illegal drug dealers have zero incentive to lace cannabis because it simply would raise the cost of selling the cannabis. There's no reason for that, and there's certainly no reason for a legitimate marketplace for, you know, a corner store or a grocery store to, you know, deal with laced cannabis. So we certainly would not, we don't see it in the black market today. We certainly would not see that in a legal market. The bill is, you know, it's a complicated statute, so there's a lot of changes that it proposes, and maybe I'm missing it, but on page 2, section, or I guess just after line 10, it proposes to amend the RSA to strike marijuana from some of the penalty sections, specifically section IB and IC, which deals with marijuana in a quantity of 5 pounds or more, or marijuana in a quantity of 5 grams or more, but it doesn't seem to deal with 5 grams or less, or 3/4 of an ounce or less. Maybe that's somewhere else that I just haven't seen it, but that's what comes after those two. So we're striking those two. It would seem we should strike the people who have it for sale for less than 3/4 of an ounce as well. Again, this does get us closer to treating marijuana as the plant that it is, and so I support it. Thank you. Happy to take any questions.
Thank you.
Thank you.
Ma'am, did you wish to testify? Thank you for filling out the card. We need to, for records.
I just wanted to add a little bit more information to the question that Representative Newell had asked, I believe it was. In the therapeutic cannabis program, one of the things that the Medical Oversight Board is working on is actually collecting data that can be used for educational and informative purposes. We are seeing very significant numbers so far that you know, we're not prepared to give out this percentage at the moment, but we are seeing significant numbers on individuals being able to decrease opioid use and the use of other hard narcotics from their system. And I personally myself have had that experience. I've been a therapeutic cannabis user long before therapeutic cannabis was legal in the state of New Hampshire, and had it not been for my ability to use cannabis therapeutically, I do not believe that I would be standing here today to talk to any of you. I would probably, if not be dead, I would be incarcerated. So I did want to throw that little tidbit in there because I think it is important to know that, you know, no matter how we choose to go forward with legalization, that there are positive impacts and that individuals are allowed to be and create a positive position for themselves within society that does not have to involve a lengthy criminal background.
Thank you for adding that. Are you wishing to testify on this bill, sir? Chair recognizes Representative Bogert.
Good afternoon, Mr. Chairman, fellow legislators. I'm not going to talk about statistics or how good, bad, or indifference anything is. What I'd like to talk about is some common sense, okay? We live in the live free or die state, and a lot of the problems with making pot illegal is the fact it doesn't make any common sense. Some people say, well, it's a lead-on drug that leads you on to other drugs. Well, one has to ask themselves, is that really true? Okay, now let's think about alcohol. Alcohol is a legal drug, okay? Does it lead to alcoholism? Yeah, some people become alcoholics, but a greater majority of the people do not. So it's called self-constraint, self-control, and being able to do and enjoy it the way one does in their own home. Let's look at cigarettes. Cigarettes, we know for a fact, kill people. Okay, I don't need to quote the numbers. Everybody knows them, okay? You smoke, a greater majority of you are going to die from something from the cigarette, okay? Do we regulate it? I think we only say you got to be 21 to buy it, and then other than that, you do what you want, okay? You might regulate where it is, but for a non-smoker, I'm a non-smoker, I still have to put up with the smells and stuff and the cigarette butts and everything else, but that's okay. That's the choice people get to make living in a state that's called live free or die. So pot, cannabis, or however which way forms you would like it. If enjoyed in the right way at your home, being 21 years of age, then why wouldn't you be able to enjoy it? Yeah, I don't think anybody's ever heard of a violent crime coming out of someone who smoked a joint, except maybe to a Dorito bag or something they might have got a little vicious with. But if you had to look at it, how many people drunk has caused problems that had too much alcohol? You've seen more people incarcerated being drunk, causing trouble, real trouble, than you have for smoking a joint. Okay? Cigarettes. Let's go back to that one. If you took a smoker, let's say they smoke a pack or two a day, and you put them in a situation where they cannot have a cigarette, you've watched them. They become antsy, they become irritable, they become outright, I need to move out and have my cigarette, okay? I have not seen anybody, you can tell I've been around a few years, and I've never seen anybody go, I need to go have a joint, They go home, they enjoy themselves, they listen to music, they watch, hopefully not the news, and they relax. If you're looking around the states that are around us, we're the island within everybody else moving on. They have more live free than we do, okay? And the other problem it creates is, as a resident of New Hampshire, if you cross the state line, you're now breaking another law. If you go and get your pot and bring it over the state line, you're breaking other laws. So does that really make sense to criminalize people for something that, if you go back to the history of it, shouldn't have never been illegalized anyway? It was brought on by a rope company because the plant was used for rope. And then the alcohol business got on board because it was a cheaper way for people to enjoy themselves than it was for having to go booze. And so it's common sense. We're continually taking our youth, and I fair say most of you in here have had a youth where you've sat and done something questionable, and you had to question yourself later in life. Oh, was that stupid? I don't know. It's part of what makes you you. You know, so the legalization of this is only the next step of the evolution of our society. You know, you can look at the numbers for alcohol. The sales in New Hampshire are going down. Why? Who knows? You would expect it to be at least flat or going up, but it's not. So, are people finding another way to enjoy themselves? If people are allowed to live their lives responsibly, people will responsibly live their lives. The greater majority. And I can't speak for the less than, because that's the problem in society. Not everybody is able to. That's why you have alcoholism. It's a smaller percent. Not everybody enjoys a scotch when they go home, or a cold beer. Are they alcoholics? No. So if someone goes home and enjoys an edible or whatever it is they call those things, and doesn't do anything else, what harm is it? I would say, common sense would say, none. You're tying up all your public service forces, tracking down people, making criminals out of people who are doing nothing but exercising their right to live free in their home and enjoy. Thank you.
Representative Pearl.
So excuse me.
Okay. Sorry.
So with alcohol, there's a way to tell if you're over the limit and unable to drive. Is there a test for marijuana or cannabis?
My understanding currently, there's not a test, but they are already looking at it. There was some promising stuff coming out of Canada for testing of that. But currently, I believe there is no way for testing of it.
I'm good. Thank you.
Representative Saley.
Thank you, Mr. Chair. Thank you for taking my question, Representative. We heard this morning, we heard HB 643, which was also about legalizing marijuana, but it was also in favor of creating state stores for the sale of it that would then be regulated much the way that New Hampshire regulates alcohol sales. I'm curious, in your opinion, whether you think just completely decriminalizing it so anyone can grow it, sell it, distribute it without any regulation is the better choice, or whether you think having some form of structure to ensure the safety and purity of the product is better.
Well, thank you for your question. That's a double-edged sword, as one might say, because you're getting rid of regulations and creating regulations. I do believe a gentleman just earlier indicated it's a plant. So how do you regulate someone growing something in their house? Okay. Are they doing something wrong? If they grew a tomato plant in their house, would anybody care? As long as they're not selling tomatoes, unless they're a farmer or something. So I would look at it this way. If you want to regulate it and put it in the store so that you can see it, you can look at it as selling a bottle of wine. You could look at it as selling beer. You sell beer and wine with the regulations there set forth. in all the stores. So you sell, we contain the liquor to the liquor stores. All right, so if you wanted to make it a little room off to the side of the liquor store, I don't think anybody cares. It might be financially beneficial to do it that way for the state, because then they could tax it and maybe make up for some of the revenue loss that we're starting to see as people's choices are starting to change in how they live their lives and stuff. So, you know, that's a way of creating some revenue if one chooses. But I think you're gonna find people are gonna wanna probably grow their own their own plant and stuff. So you can look at that as someone making a brewery. They make, what is it, 100 gallons a year or something? I'm not quite sure. But there's some similar type regulations for that. Unfortunately, I did not get an opportunity to hear the bill because I was across the street in another session. But, and I haven't fully read this one, and I do apologize for that, but I did want to make the point that there's a point in time that we just got to start moving forward, okay? The workforce, we see our unemployment is 2.6%, okay? I used to be in retail and trying to get someone with a background check. Once you've gotten arrested for something silly, you can't get a job. So now you're regulated to be in dishwashers and whatnot. And what kind of contribution is that to society or to your own family? You can't, okay? And all they're doing is doing something they feel is their personal right to do in their home. I'm not excusing smoking in your car driving down the road. By no means am I saying that, because once again, the greater majority is not there to do that. But if we looked at it as drinking, we read the newspaper every day. Don't need statistics. The newspaper spells it out in their arrest log. How many people are arrested for drinking and driving? Okay. How many people have you seen that have been arrested for something else? Not as many. I'm sure there's some. Not going to say there's none. But once again, as we grow, we got to start taking the baby steps to get there. Did that help you with that question?
Thank you.
Thank you.
Thank you for your testimony.
Thank you.
And with that, I'm going to close the public hearing on HB 360 and open the public hearing on HB 3. No, actually, no, I'm not. I got 10 minutes. We'll be in recess until 2:15. I'm so behind so long, I wanted to. You can never tell. They're all high.
It has been going and through.
But in this type of case, the lieutenant says, you know, maybe we should refer it to the police department. I says, no, you know. But when the police officer did show up, I explained to him what we had discovered. And he says, appreciated it, and, you know, chose not to react to it. But however, current state law says, technically, it is against the law to have immature plants. I mean, we did make the law that says you can have up to 3/4 of an ounce, but to grow it, it is not current. So this will allow the consumer or the person, for whatever particular reason, the people with glaucoma, other things, you know, my bones are aching myself, and I finally traversed into being an old man, but I will not admit it, you know, because I don't act it. But the thing is, for those people that would want it for medicinal purposes, this allows them to grow on their own. And I come from Nashua, and I think Representative Gathright can testify, and for those of us who live close to the borders, that in Nashua, one does not have to go very, very far to pick up cannabis. You know, you just go over the line into Tingsboro. It doesn't seem to be any, you know, armed guards or people at the border or anything else like that. So it's more like a choice. I think this is a wise decision. It's a small amount. I think it encompasses something like only 3 immature plants. And I think it's well worth the try to see, worth having it and see if it fits within the needs of the community. And for that, I'll end it at that and available for any of your questions. You guys are good. Thank you very much.
The chair recognizes Frank Knack. I don't think he's in here. Oh, there he is.
Is that on? Sorry. Mr. Chairman, members of the committee, thank you so much for the opportunity to testify. My name is Frank Knack. I'm Policy Director with the ACLU of New Hampshire, and we're here in strong support of HB 344. Our support for marijuana legalization in this bill in particular is really through 2 lenses. One is harm reduction, and one is racial justice. And starting with the racial justice lens, so marijuana is the quintessential issue to kind of look at race disparities because we know from substantial research that black people and white people use marijuana at roughly the same rates. And so we can have apples to apples comparison about what's happening on the ground in our communities. And nationally, so ACLU has done a number of studies on this, looking at FBI UCR data. So this is official data given to the FBI that we've analyzed. And so nationally, black people are 3.6 times more likely to be arrested for marijuana possession than white people. In New Hampshire, it is substantially higher, 4.6 times more likely to be arrested for marijuana possession than white people. So this is kind of a quintessential race disparity issue. And when you think about it and the kind of collateral harms and how those impact the racial wealth divide, this is a great opportunity for us to start to repair the historical harms that our history has had, particularly in black and brown community members. I think it's really also important from a harm reduction lens to look at this issue. So when we passed decriminalization a few years back, you know, there's this thought process that no one is going to jail for marijuana anymore. And while there may be very few people going to jail for marijuana, people can still get arrested for marijuana possession, and people still are getting arrested for marijuana possession. So again, looking at FBI UCR data cited in our fact sheet, over 1,100 people were arrested for simple possession of marijuana last year alone in New Hampshire. And so as we talked about earlier with collateral consequences, even a misdemeanor marijuana arrest has severe collateral consequences, including 99 mandatory collateral consequences that attach to it. And so it impacts, you know, your ability to get housing, to get employment, et cetera. And it's something that's unhelpful and ruins lives. And also I'd like to talk about a few of the concerns we've heard raised from others currently opposed to this effort. And so there's been a lot of talk about how marijuana legalization has somehow increased youth use in states where it is legalized. And so again, I think it's really important to look at what academic peer-reviewed studies have found. So this is a study from the Journal of the American Medical Association looking at youth use in states that have legalized. And so here, according to that study, recreational marijuana laws were associated with an 8% decrease in the odds of marijuana use and a 9% decrease in the odds of frequent marijuana use by youth. And so this tracks with other research that has shown that there's been no uptick in marijuana use among youth in states that have legalized. Another issue is traffic fatalities. And so, again, looking at the research from other states, there's been, quote, little to no effect, unquote, on traffic fatalities and accidents in other states. We've also heard about the opioid crisis, which is a very real problem, as we talked about on the last bill, or a few bills ago. We have really good solutions in this committee this year and in this body this year around drug testing kits. But evidence suggests that marijuana legalization is connected with reduction in opioid-related deaths. And so this, again, is a tool for addressing, as we heard, I think, in earlier testimony, it is an alternative to reducing opioid harm in our communities. And finally, there's been a lot of talk of crime and how legalizing marijuana in New Hampshire would lead to an uptick in crime. And so again, looking at the facts, which we think are important, we heard testimony from the chiefs last year that when marijuana legalization began in Massachusetts and then went on to Maine and Vermont, that we had a spillover effect in crime in New Hampshire. So again, we have the benefit of actually going to the data and seeing what's actually happening. And so we did. We looked at what happened, and then we looked at State Department of Safety crime stats between 2016, which is the year Maine legalized, and 2021, which is the most current year available of full data. Crime is down 26% in New Hampshire during that time. And so this notion that there's been spillover crime, again, is not based in any reality or based in any data. Happy to answer any questions and really encourage your support. Thank you.
Representative Mann.
Thank you, Mr. Chairman. Thank you for taking my question. You spoke specifically about youth use, and I don't know, unless I'm reading this wrong, this bill would essentially would decriminalize the use of marijuana for those under the age of 21. And for those that want to reference it, it's on page 3, line 20 through 25, where it makes it a violation for those under 21 to knowingly possess 3/4 of an ounce. I just wanted to know what your position was on that.
So it is still a violation. And again, looking at the stats from states that have gone to legalization, we have not seen an uptick. So again, this is where it's really important from our perspective that we engage in robust public education, because we're not here saying that marijuana use is harmless. It's not. But criminalizing marijuana use, which is what we're currently doing, and giving people criminal records and putting all these unnecessary hurdles in front of people is problematic. And so we would absolutely support robust public education efforts, not only for marijuana, but for all drugs, and to move towards a harm reduction lens approach to substance use.
Representative Bolden.
Thank you. Thank you for taking my question. Earlier, I think either I misunderstood you or maybe you misspoke, and I was hoping you could speak to it again. What were you saying was the difference between pre-2016 and post-2016? And I think you said that's when we legalized, but that's when we decriminalized. Do I have that right?
Oh, sorry. I was talking about, I think that was in the context of arrests and spillover crime. And so there was testimony from the chiefs last session that when our neighboring states began to legalize, we faced spillover crime in New Hampshire, and they used that as an indicator to say that if New Hampshire followed suit, we would again see an uptick in crime. And so we looked at the data from 2016, which was the year of the first legalization state among our borders, which was Maine, I believe, and then through 2021, so I think it was Vermont, Maine, Vermont, and Massachusetts, I think we're like 2016, 2017, 2018-ish. And crime is down 26% in New Hampshire during that time. And so this notion that there was spillover crime is just not backed by any actual facts.
If you have the information, if not, if you could get it, what about Massachusetts? Since they legalized, what's their crime stats like?
I'd be happy to pull that and send it to you.
I appreciate it. Thank you.
Absolutely.
Representative Salick?
Thank you for taking my question. Sorry, we're sharing a mic. So, I'm going to ask you a similar question I asked one of the previous speakers. Regardless of what method the state uses ultimately, whether it's this year or in the future to decriminalize marijuana, because clearly we're going to eventually get there, do you believe that it should have regulations or just be as free as one of the previous speakers said, as growing tomatoes, which are actually regulated?
From our perspective, HB 6, I believe it's HB 639, which was heard in Commerce yesterday, is the ideal bill to move through this legislature. That is a bill, and I'm not sure how much I can talk. It's okay if I just say a few sentences. That is a bill that is co-sponsored by, or is prime sponsored by Leader Osborne and co-sponsored by Minority Leader Wilhelm, and reflects the consensus of a broad, diverse coalition of advocates and stakeholders who have come together over the past 7 or 8 months. It includes robust testing, it includes robust youth protections. The limits are, in terms of possession amounts, are higher. It includes annulments to start to repair the lost harm, the past harms from prohibition. So that is our ideal bill, and it addresses all those issues, including advertising to youth, safe packaging, et cetera.
Thank you for your testimony.
Thank you so much.
The chair recognizes Matt Simon.
Thank you, Mr. Chairman. Can you all hear me all right? For the record, my name is Matt Simon. I work for Prime Alternative Treatment Centers of New Hampshire. They're a nonprofit therapeutic cannabis alternative treatment center, dispensaries in Merrimack and Chichester, a cultivation facility in Peterborough. We have about 55 employees, and our focus is entirely on serving great patients who are registered in New Hampshire. Prior to taking that job a year and a half ago, I spent the last 15 years working on cannabis policy. I've been before this committee many times, advocating for bills much like this, and in fact, I think identical to this. So this is actually a handout, the one-pager I've given you that I created 4 years ago when I was working for the Marijuana Policy Project. I updated it a couple weeks ago and got my colleagues to sign off on it, so it's still their document, but it has the updated laws from the rest of New England, which at this point, the document is entirely filled in. It is now legal for patients and adults 21 and older in every New England state except New Hampshire to grow limited amounts of cannabis for their own use. The only exception is Connecticut, which will take effect on July 1st of this year. So that is in statute, but not yet in effect in Connecticut. So when we talk about cannabis legalization, we're really talking about two separate issues. One is legalizing possession, getting people out of the criminal justice system, and the other is regulation, taxation, consumer protection. The first issue turns out to be much simpler. It's way easier to just stop punishing people for possessing cannabis. And the other issue turns out is a little bit complicated. There are a number of bills that have been filed. I think there are going to be a lot of proposals to maybe amend them. There are a lot of policy choices that have to get made. So it tends to be more difficult to build consensus around regulation policy, but I'm hoping that we will reach consensus around this much simpler criminal justice reform. I should point out, Prime ATC is not going to benefit from this in any way. It actually hurts our business, but much like with alcohol, people can brew their own beer, and if any alcohol company came in here and said, no, there should be felony penalties against home brewing, I don't think we should like that very much. So as an ethical cannabis business, supporting the right of adults to grow their own cannabis is very important to me. It's important to our leadership team, so we're here to support it, and would note the benefit that would be tremendous for patients who have been practically begging for this for the last 12 years and have been rejected and come very close and failed many times. So it's still a felony to grow your own cannabis. Even if you're a registered patient in New Hampshire, this bill would change that, so would another bill. But be happy to answer any questions. Thank you.
Representative Newell.
Thank you for taking my question. I'm curious, between the difference with therapeutic use being grown in a setting other than someone's home, or growing it in your backyard garden, perhaps right next to your tomatoes. Is there, with other substances, there is a harm that if it is unregulated and untested, that many times you will find something, it'll be more harmful, right, to get it in that way. Can you speak to that potentiality when it is grown in your backyard, perhaps right next to your tomatoes?
Absolutely. Thank you for the question. So there are risks with cannabis cultivation. Mold is a major one if it becomes damp, particularly after it's harvested. These are issues both in the regulated market and for home cultivators. Our hope is that with home cultivation becoming legal, that we can do the sort of public education that will allow people to cultivate responsibly for themselves and know, as with their tomatoes, that they're not putting something harmful onto their plants that will hurt them. In the regulated market, there are unethical companies, and there have been documented instances in other states where regulators have had to step in and say, hey, you're adding stuff to your cannabis, we have independent lab testing, and you're failing it. There are, in a regulated market, there's a way to deal with that. In an unregulated market that currently serves New Hampshire, there is no product control, so people don't know what they're getting. If you're buying it from an unregulated seller, the so-called illicit market, you have no idea who grew that cannabis or what may have been added to it, and whether it's moldy or full of heavy metals or pesticides. So people who buy from the ATCs know that the products are independently lab tested and labeled according to what's actually in them. Most people want that regulated market, patients and adult consumers, but as with alcohol, for people who feel strongly and have trouble, frankly, affording the regulated products sometimes, it's a cost-effective option, and most importantly, it's one that should not be criminalized in our view.
Can I follow up on that? Thank you. I think, I'm sorry, because I didn't frame the question very well. I should write these things down, but it comes out better. My question is, I think what you're talking about is, mold and things like that. These are things that would happen with, any plant when you're growing it at home. My question is to the level of potency. So if you're growing it in your backyard, is it suddenly going to be ridiculously more potent than you get it at, in a therapeutic setting, or would it be, do you understand? I'm sorry, I'm not saying it right, but do you understand?
Thank you for the question, and it's hard to hear in here, so part of it is probably my ears either being full of wax or the bad acoustics, but I think I understand, certainly from a patient perspective and from adult consumer perspective, being able to know the potency of the cannabis you're consuming is important. Think about alcohol. If you walk into a brewery and you don't know whether that liquid in front of you is 4% alcohol or 9% alcohol, that's going to have a pretty important impact on how many you're going to consume and how you determine whether you're impaired or not. So that's a benefit to the regulated market. Everything that's sold in the ATCs, everything that's sold in regulated businesses anywhere is labeled for the potency. So that's a downside of home grow. But if you're growing at home, first of all, it's very challenging to grow high potency cannabis. So most people are not going to be able to achieve the high end of potency. But even if they can, they're going to work up to that. And if they're like most people, they'll realize that potency isn't really what they're most interested in. The people who use cannabis are trying to feel better or less bad, and the highest THC product isn't necessarily the one that's going to do that. So people don't know how much is in their home brew either, generally, but they have an idea. And in my ideal world, which I think we can get to without too much difficulty, there will be independent testing labs available, so if you want to get your home grow tested, you can find out. Thank you.
Thank you for your testimony. At this time, the chair recognizes Paul Toomey.
Thank you, Mr. Chair. My name is Paul Toomey. I'm from Chichester. I'm The former House Counsel, and it's really an honor to be back here. I've spent almost my entire professional life litigating against governmental entities, and I must say, the only one I really love is the New Hampshire House of Representatives, so it's really an honor to be here. And I enjoyed being House Counsel. I was also a member of the 2017 commission that studied the question of legalization of marijuana, and at that time I was one of 2 members that were charged with reviewing all the scientific and medical data and then reporting to the committee. That report's available, and if any of you have an interest, I'd urge you to take a look at some of the studies that were referenced in the back sections of it, because it'll answer a lot of questions that people bring up about traffic safety and health and things like that. I was also, for 40 years, a criminal defense lawyer, as I said, and I was a public defender for 10 of those years, first in Manchester, where I was the office manager of the Hillsborough County Public Defender's Office, and then I became the litigation director for the entire state program. I presented and submitted written testimony, and I'm not going to go over everything I said in there. I'd just like to add a few things. I think the reason I'm here really is because I've spent my life representing poor kids. I was a poor kid myself. I grew up on welfare. My friends were all poor, working class kids, and I know what these laws do to people like that. What they do is they steal their future. They make it so that even if kids don't go to jail for it, it's really difficult to get a job. It's really difficult to get housing. That's also true, by the way, for veterans. I represented a lot of veterans who have had problems getting, being afraid they were going to get thrown out of their VA services or subsidized federal housing because of simple marijuana possession charges, and that's a population you should keep in mind. When you go to court for the last 30 years, when I first was a lawyer, if you got busted with pot, you risked actually going to jail and getting, doing some serious time sometimes, up to 12 months. After about, say, the mid-'80s, that just sort of stopped. For the last 20 years, I have never seen a person plead guilty or get convicted of possession of marijuana who walked into court with a lawyer. I have seen hundreds of people get convicted who went to their arraignments without lawyers and knew they couldn't afford a lawyer and knew that if they asked for the state to appoint a lawyer, it was going to cost them $300, $600, and if they couldn't come up with that, they were going to end up in jail. Those kids are the ones who plead guilty nowadays to possession of marijuana. Those are the kids who get driven out of the workforce, and when you get driven out of the workforce in this country, you go to the crime force. I mean, it's just that simple. People have to survive, and they're going to find a way to survive. And if you make it so that somebody can't earn an honest living, they'll earn a dishonest living. We don't need that. We need people working. You go to any store, any business in this state, and you'll see they're just dying for people to work. But most of them won't take a chance on hiring somebody with a drug record. So we just have to stop that madness. It doesn't do anything, doesn't change any behavior. Anybody can get marijuana anytime they want. They can either buy it on the street from a full-service drug dealer who's going to give them access to heroin and cocaine and fentanyl and anything else they want, or they can go to Massachusetts, Maine, Vermont. Nobody probably goes to Canada. It's a little too much, but you can go in any direction from New Hampshire and get marijuana if you want. So you're not changing anybody's behavior. What you're doing is driving it underground. I've heard some people say that, the drug dealers will just undercut the price and it doesn't matter. That happens if you get greedy and put the taxes sky high. But if you make it sort of the way we deal with alcohol, and that there aren't, either make it a free thing where people do it themselves or make it cheap enough, that won't happen. You don't ever see people selling alcohol on the street corners. At least I haven't seen it for a long time. There are several bills before the legislature with commercial models, and I am a member of the coalition with the ACLU and AFP and Marijuana Policy Project that helped draft 639, the majority leader's bill, and that's the bill I support. But I think it's critically important to have this alternative available because there's a lot of disagreement about the best way to go forward with a commercial system, and none of those bills may pass. But we have to stop the madness. We have to stop, just criminalizing poor kids and keeping them, basically stealing their future. So I guess what I would ask you to do is, I think this is a very important bill. I ask you to pass it so that there's an alternative. If all those other bills fail, at least we can stop harming people. Hippocrates said 2,500 years ago, first do no harm, and we need to stop doing harm. We've had a model for 60 years of treating health problems with police resources. It hasn't worked at all. The problem's gotten worse and worse and worse. We have the worst drug problem in the world, and we have the most stringent drug laws in the world. They just don't do it. If you want to, there are health problems associated with any substance, but we need to stop trying to treat them with cages and start trying to treat them through our health system. And I don't have anything else. Thank you very much for listening to me.
Representative Selig.
Thank you, Mr. Chair. I actually have a procedural question. This is the second mention we've had of HB 639, which my understanding is went to the Commerce Committee. Does that, if it passes through Commerce, then come to us?
That'll be a determination that'll be up to the speaker. I don't know at this point, nor do I know why it went there instead of here, other than perhaps logistics.
Thank you.
I couldn't hear the question, but did
It was for me. That's
Oh,
okay.
okay.
I have a question for you, though. The study you referenced, is that available online?
I'm sorry.
The study that you referenced, that you
It's available. I think it's available on the House website. I can send it, the link to you. I think it's still up on the House website.
I'll check with our committee researcher. Thank you very much.
Yeah, just, if I could just say one other thing about that. There's a NHTSA survey in there on traffic accidents, and it's really interesting. It's kind of counterintuitive. They end up saying that marijuana does things that make people worse drivers, inattentive, da-da-da-da-da. But it also makes them drive slower because they're paranoid. So NHTSA ended up saying it's sort of a wash. That doesn't mean anybody should go out and ever drive on any substance, but it's interesting and it's counterintuitive.
So it's a lot of slow speed crashes.
Yes, slow speed crashes. Thank you. Any other questions? No. Thank you.
And the chair recognizes Dr. Hannan.
Hello again. Obviously, I'm in favor of HB 344 for home cultivation. I believe I was the other scientific reviewer for the commission for the study back then. And the speed thing was pretty funny too, because we talked to some law enforcement officers. Like, can you tell what someone's using during when you're pulling someone over? Like, well, someone's speeding and swerving, we know they're drinking, and if someone's doing 35 in the slow lane and not even doing anything but going 35 miles an hour, they're driving otherwise safely, like they're probably using just cannabis. So it was interesting study that we heard. So I think this is a very important bill, even if any of the other cannabis bills pass, any of the full legalization, whether it's retail or state stores or private retailers, commerce or criminal justice bill. I think it's important that this pass even as a standalone bill, not just as a backup, just in case, but I think it's important to allow home grow, no different than home brewing, like we've heard of alcohol and of wine and beer. When I was on Commerce, I did a lot of Commerce Committee, did a lot of discussions about all those laws and regulations. There's no real oversight of home brew. So if anyone's worried about oversight of home grow of cannabis, it's probably going to be no different than home brew of beer and wine. There's no mass epidemic of problems with home brew beer and wine, even though you can have 100 gallons of each. If you want to do 100 gallons of wine, 100 gallons of beer. If you're married, you can have 200 gallons. That's a lot of beer and wine. This doesn't even come close to those levels as far as usage levels. I think this is a drop in the bucket, but it's a great start. We also have the influence of other states around us. We heard testimony already of not being able to afford things. I'm pretty well off. I can afford eggs nowadays, but not everyone can. Am I going to run out and buy chickens? I've actually had this discussion with my wife. 2 doctors talking about getting chickens because it's a little expensive. We're pulling it off, but we've had the discussion. We're not growing tomatoes yet. It's not that different. We do have an herb garden on our countertop, though, where we grow oregano and basil, but we're getting little plants. I've actually killed a cactus before, so this bill would not help me one bit if I decided to grow anything at home. We're also looking at the influences of a home grow for not just choice and also people that aren't able to afford going out or driving, putting $5 worth of gas in your car and driving to another state. You know, it also gives someone the option of not, you know, supporting big businesses that they don't want to support. They want to support, you know, since we don't even have mom and pops, they don't have to go support big business. And currently, even if someone's buying on the illicit market, they're supporting big business, the cartels. Everyone talks about they don't want big cannabis to come to New Hampshire. It's here. It's run by cartels and criminals. So it already exists. We want to make it safer. Are people going to be poisoned by this at home? They're less likely. I mean, very few people use pesticides at home when they're growing little plants and gardens. There are also the mental and physical health benefits of gardening. There's many studies out there. I don't have them offhand, but I'm sure you could quickly Google some of the benefits of gardening for reducing anxiety, stress, and the physical benefits. It's definitely something to consider. This is only for adults. Children are not going to be doing this. I'm not worried about my 16-year-old son doing this because, first of all, it will be illegal anyway because this is only for adults, and he can't even clean his room, so I'm not worried about him starting a garden. And as far as the legality, like we've heard, it's everywhere. Nobody really has a problem of getting it. This is just an option for people who would like to do it. And it is a hobby for some people. No one's going to be selling it. It's not allowed to be sold. They can give away a small amount. So it's not even like the person, like I was thinking, if I get too many eggs, when we get those chickens, I can make a few bucks selling them to offset the cost of my new hen house and feed. You can't even do that with this bill. You're not going to make money. It's not going to support another business. If someone does it, they'd be breaking the current law anyway, so it doesn't make any difference. And the amounts are so small anyway that you're not going to have a thriving business with a few little plants that you can barely get going. So, and the last point, as far as the pervasiveness of cannabis in the state, we know it's easy to get. I mean, it's been used and sold within about 50 feet of where I'm standing, at least once that I know of. And I think it's been reported in the paper too. So this is not a problem that is outside these doors. This is a problem that has been inside this building, and this is not going to make the problem worse. This is not going to be something that's going to really affect much more than a few people that can't afford to go out or just have a hobby they'd like to enjoy and maybe have a little safer product that isn't contaminated with pesticides or whatever else the cartels are using nowadays. I'd be happy to take any questions.
Thank you. I have a few. First of all, chickens are mean. I have them. I would not recommend them.
I'm sorry, what?
Chickens are mean. I have some.
Oh,
I would not recommend.
As a child, so I didn't want to bring that up. It's
Good.
actually
So from a law enforcement perspective, you paint a very bucolic picture of, you know, the family having a little plant and it's nice, they're talking to it. But from a law enforcement perspective, if we were to legalize personal growth, how, from a law enforcement, the way that at least they used to be able to detect growth that was illegal in a home is, one, you'd look at it from a thermal camera and it would glow. In New England in the middle of winter, if you have a grow going, you pull the electric bills because those lights take a lot of energy. Of course, now they're LED too, so that went green as well. But how is a law enforcement officer to determine who's running an illegal grow operation in their basement versus the hobbyist?
Well, the higher amounts would still be illegal. I'm sure they're going to employ the same methods they're currently using. So nothing would change there, except they might show up and be disappointed that it's only a hot tub, bed, maybe a steam room, and 3 plants. So there may be some disappointment for not having some of the larger busts, and that's the only downside. They're going to still do what they're doing. And most of the people I've talked to, I definitely, there's officers out there, we've heard them, that it's a horrible problem we have to stop. I've yet to hear one talk about busting a big still operation where people are making too much beer and wine at home. I mean, it might happen, but it's not something I've never heard in this state. So.
I believe that's more of a southern problem. Representative Bolden.
Thank you. Thanks for taking my question. As you are a man, maybe you could explain man things. I have been witness to beer brewing, and beer brewing, legal beer brewing in New Hampshire, and I observed that costs to purchase the equipment were shared between friends, and there was sharing of the final product. Is that legal to your knowledge currently?
I don't think there's any prohibition on like the components of any of the things for making this stuff. I mean, you can make any of that stuff with just stuff you can find in any store. You don't have to buy a separate thing. There are kits you can buy. You can mail order wine kits and beer kits. During Prohibition, there were actually you could buy kits online, not online back then, but you could buy kits through the Sears catalog or whatever it was back then, and they could make it at home. So I've never done it as far as beer and wine. As someone who took a lot of chemistry classes as an undergrad, I was aware of how to make certain things, but I never really shared flasks and beakers with neighbors. So.
No, thank you for testifying. Is there anyone else wishing to testify on HB 344?
Again, for the record, my name is Heather Marie Brown, and I am in support of home grow for New Hampshire citizens. I think that this will serve just about every citizen that wants to take part in this, including therapeutic cannabis patients. For me, I know one of the barriers of a patient to overcome is access and affordability to their cannabis. Well, by allowing home grow, whether for adult use or medicinal purposes, that gives me another option to cut down on those costs and expenses to have the access to what it is I would like. In my own personal opinion, growing cannabis is not any different to me than growing tomatoes or cucumbers. And I've often found it humorous of, you know, what a big deal we make about the subject, but nobody's outlawing tomatoes and cucumbers, and they present a lot of the same issues with contamination, mold, and things like that as well. I do also think that by allowing home grow, you are taking away another piece of the puzzle when it comes to criminal activity within the state. You are giving citizens another option instead of going an illegal route or jeopardizing by crossing state borders. I think that this is a great start and an excellent way to start showing that we care about New Hampshire citizens' safety and that we actually want to make an improvement in crime in regards to cannabis in the state. Thank you.
Thank you for your testimony. Is there anyone else wishing to testify on HB 344? There being none, I will hereby close the public hearing on HB 344, and the committee will be in recess for 5 minutes. 3 o'clock, I'm going to open the public hearing on HB 328. And who's going to introduce it? Is anyone here to introduce it? Yes, please.
Thank you, Mr. Chairman. For the record, my name is Representative Jennifer Rhodes. I represent Cheshire District 17, Winchester, Richmond, Marlborough, Swansea. I'm sorry, no longer Marlborough. Winchester, Richmond, Swansea, Fitzwilliam, and Troy. The prime sponsor is not here for House Bill 328. I'm just here to make the introduction.
The chair recognizes Dr. Hannon.
Thank you for hearing me again. I just want to talk about a couple brief things about some of the substances. It basically addresses psychedelic substances, which are generally considered not addictive, and the main effect people get are, visual sensation changes. People do not get compulsive use. They don't feel like they have to use it. They don't get any withdrawal if they don't use it. The only negative effect of using it over time is there can be a decreased threshold. You might have to take a little more to get the same effect over time. The substances have been around. LSD is one of the newer substances, some of the more synthetic ones, but some of the other things like peyote and mescaline have been around for millennia, have been used in for spiritual purposes, recreational purposes. In fact, the founder of Alcoholics Anonymous, Bill Wilson, one of the co-founders, relied on it heavily and used it as a tool, considered it a part of a tool for the 12 steps. So before, when you heard me say about the history of substance use treatment in this country has predominantly been abstinence-based, it wasn't always that way. In the very beginning, one of the founders was a strong proponent of psychedelic substances like LSD for a spiritual awakening. And his spiritual awakening that he wrote about and founded a lot of the 12 steps on was from an experience he had under the influence of LSD. He even wrote to the Swiss psychologist Carl Jung back in '61 about it, talking about the need for a spiritual awakening for some what they called die-hard alcoholics at the time. And it's not something that they require. I mean, I went to AA for years. It's not something they gave out in meetings. They don't do that. It's not something for everyone. Even Dr. Carl Jung and Bill Wilson from AA didn't say it was mandatory. But it was just a tool that was available. I did some, I know that it's not addictive, so I was wondering why it's even a Schedule I. It was just a question, and I kind of knew this, but I forgot, doing this for a while, so I looked it back up. And I found a little pamphlet from the National Drug Intelligence Center. It's a component of the U.S. Department of Justice. And it says, this little handout says, is LSD legal? Yes. Schedule I substance under Controlled Substance Act. Schedule I drugs, which include heroin, MDMA, and they have a high potential for abuse and serve no medical purposes. And then in the same pamphlet, it says that, where is it? It's not considered, in the same pamphlet, a different section, it says it's not considered addictive, an addictive drug, and that it does not produce compulsive drug-seeking behavior as cocaine, heroin, and methamphetamine. However, they can develop resistance over time and need more to get the same effects. So it's illegal because it's a Schedule I drug and has no medicinal value, and it causes compulsive use. And the same pamphlet for the government is telling us it doesn't really do that. They don't even have their story straight. This is not something that has been a scourge or a problem in any way. People do use it. Now, could someone do something under the influence of a psychedelic substance that might not be safe? Absolutely. but that doesn't mean that it's a compulsive addictive substance. So anyway, that's really all I have. I'd be happy to answer questions on it, and that's about it. I know there's probably not a lot of speakers for this bill, so I'll shut up now.
There be none. Thank you for your testimony.
Thanks.
Chair recognizes Derek Januszewski.
Thank you. I'm here to speak in favor of this bill. I wanted to give some supportive testimony to the gentleman who just spoke. I'm a member of Alcoholics Anonymous. I have had some addiction in my background, and I see the terrible, terrible effects of that addiction, not just inside the rooms and inside the halls of AA, but on the streets of Manchester where I live. It's everywhere. It's really a problem. However, as the gentleman before me said, the LSD is what Bill Wilson received his spiritual awakening on. The whole premise of Alcoholics Anonymous is based on a spiritual awakening and a spiritual experience. Having connection with conscious contact with a higher power is the only thing that's going to relieve the symptoms of alcoholism. So this is the foundation of the most popular and most successful recovery program in the world has ever seen, this substance, LSD. And to speak to the safety, a normal dosage is between 50 and 150 micrograms. Now, there's never been a recorded death from an overdose of LSD, and the guess at what an overdose would look like would be 14,000 micrograms, okay? That would be 14,000 micrograms, about 1,400 times the normal amount. There's been 0 overdose deaths ever. As a matter of fact, there's been 0 deaths due to LSD ever. And it's been used since 1943. There have been some other deaths that have been a result of the behaviors, but none from the drug. Psilocybin. Psilocybin, according to the National Library of Medicine, says of all the psychedelic drugs, psilocybin is reported to have the most favorable safety profile. The vast evidence-based data that exists for psilocybin suggests that psilocybin may be the most efficacious psychedelic drug for treating mood and anxiety disorders. That's from the National Library of Medicine, studied by the U.S. government. And the diseases that it treats, according to the National Library of Medicine again, alcohol dependence, stimulant dependence, cocaine addiction, tobacco addiction, nicotine addiction, opiate addiction, cannabis dependence, anxiety disorders such as PTSD, generalized anxiety disorder, obsessive compulsive disorder, advanced stage cancer-related anxiety, psychological distress associated with existential crisis of terminal diseases, and adjustment disorder with anxiety, along with a whole litany of other mental health issues. This is a solution to the drug problem, not the drug problem. As far as psilocybin overdoses, the overdose would be, for a 150-pound person, would be 19,000 micrograms. 19,000, that's 1,900 times the normal amount. Just to put it into perspective, that's over 60 pounds of fresh psychedelic mushrooms that somebody would have to consume. You'd literally have to choke to death to die from psilocybin mushrooms. Mescaline, which is found in peyote, a practice that's utilized by Native Americans, and also another plant called San Pedro. According to the National Library of Medicine, mescaline addiction and dependence are practically absent, and it is clear that most intoxications appear to be mild and are unlikely to produce life-threatening symptoms, which favors contemporary interest in the therapeutic potential. These are in a different class of drugs because they're a different class of drugs. They're purposely put into a different class of drugs. They're psychedelics. They're not stimulants. They're not opiates. These are not destroying America. There's nobody going out, like I said the last time when I saw you guys on, nobody's going out to cut out a catalytic converter to get more mushrooms. This is not a public safety issue. As a matter of fact, this is a public health issue. And from there, I'll pass the time.
I recall many years ago reading that LSD caused the loss of brain cells. Is there any truth to that?
There's absolutely no truth to that. There was a lot of propaganda, and I won't go on and on about that. There's a lot of misinformation that has just been carried forward.
There be no other questions. Thank you for your testimony.
Thank you.
Is there anyone else wishing to testify on this bill? Seeing none, I'll close the public hearing on HB 328. And the House will be, the committee will be in recess until 3:45.
That's true. Yeah, that's very true. Yeah.
No, she had So it's been 4 years. We have fine conversations.
I came here just as everything was so messed up. Every single thing was so messed up. I made it to one at the right time. I was like, are you kidding me? Like, did you guys remember to plug in your mileage? Oh yeah, I did. Get your mileage. That $4.78 for the day is gonna happen. It's better than that.
It being 3:45, I'm going to open the public hearing on HB 470 and recognize Representative Gathright to introduce the bill.
Thank you, Mr. Chair. I am Linda Gathright from Hillsborough 10 out of Nashua, and I am introducing the bill for Representative David Muse, who could not be here today. And I will read his testimony that he would have given had he been here. While others will give testimony today on full scope of the problem and related efforts in harm reduction community to save lives, I'd like to focus on what we can achieve by passing HB 470. The first thing the bill would do is provide an essential update to New Hampshire's Controlled Drug Act. Under our current law, drug checking equipment such as fentanyl test strips is considered to be drug paraphernalia, and possession is illegal. What HB 470 would do is carve out an exception in our drug law for drug checking equipment such as fentanyl test strips. It does this by specifically removing products from the current definition of drug paraphernalia that process, prepare, test, analyze, package, repackage, store, or contain drugs. The bill also adds critical definition for drug checking equipment, drug supplies, and drug packaging. It also specifically excludes drug checking equipment, such as fentanyl test strips, from our definition of drug paraphernalia. For the first time in New Hampshire drug law, the bill also defines the concept of harm reduction. Harm reduction strategies aim to reduce the negative consequences of drug use, such as overdose deaths and the spread of HIV and hepatitis, rather than trying to eliminate drug use altogether. By providing a way for users to test their drugs safely, drug checking products like fentanyl test strips are a harm reduction strategy that can help to reduce the negative consequences of drug use. One argument against making it easier for users to check their drugs for safety is that it coddles drug users and only encourages them to use more drugs. But the reality is the alternative to drug checking equipment is not knowing, and the very real risk of overdoses and deaths that add to the burden of our healthcare system and our law enforcement community every day. The bottom line is that it was your son or daughter holding a bottle of mystery pills sold to them on the street with no real assurance of what they actually contain. Wouldn't you want them to be able to perform a quick, inexpensive test that would let them know for sure? The bill will allow them to do that legally with much less risk of fatal consequences. Please send HB 470 on to the full House with an ought-to-pass recommendation. And I have a citation that was given by an organization called medicalexpress.com. You guys can go there and take a look at that. But they talk to the greater harm and the greater deaths that were soaring with Black teens in the United States. Thank you.
Thanks. The chair recognizes Dr. Hannon.
Hello again. Last time I promised for the day. I'm in favor of House Bill 470. A little background, I wrote a bill to allow syringe service programs back when I was here in 2015, I guess it was. It didn't pass, became another bill later, and now we have syringe service programs around the state, which are allowed to have fentanyl test strips and things like that be used as a part of a program, but this would allow it just in, at a broader level, and they can be given out more freely. I think it's very important. One thing we have to understand about substance use, and I've discussed this with lots of people, some of them here, is one of the most dangerous things about drug use is not knowing what they're taking. If you went to the state liquor store and you bought, well, they don't sell beer, but if you bought a six-pack of beer and 1 out of 6 beers could kill you, that's a problem. Knowing what was in every beer, if one of them was the bad one or more dangerous, that would be a good bit of information to have. And it's not just about, finding out whether something has fentanyl or not. I don't tell people that are using fentanyl to test every time they get fentanyl. Just New Hampshire has very little heroin. If they're using heroin, they're really using fentanyl for the most part. There's almost none. I can't remember the last time we've had a heroin-only overdose. They're either polysubstance use, and most of them contain fentanyl. So it's really important to test other substances, whether it's cocaine, methamphetamines, and most importantly, if they're using pills, because the black market for counterfeit pills is much greater, and it's increasing all the time. Back in the day, it was Percocets on the street were about $1 a milligram. Now it's even more. It's really hard to get because we've cracked down so much on overprescribing, and that did drop the overdose deaths that resulted from prescription drug use. But every state that instituted one of those programs had a drop in those deaths, had a corresponding increase in deaths from other street and illicit drugs. So where there's a will, there's a way. They're going to find a way to do this. And right now, one of the more I wouldn't say ingenious, but the way they're doing it is pressing pills and making other substances. So it's really important to know what they're taking. And something that didn't even occur to me until it was pointed out by one of your own esteemed members earlier is you can check your kids' stuff at home. If they've got something you're not sure about, you can check it. And I've got to go because I've got to go through my son's room when I get home. So I'd really appreciate if you pass this bill. It's definitely a life-saving bill, no matter what you think about it being enabling behavior or anything like that. It's enabling people to check to make sure something is what it says it is. And we want everything to be what it says it is. And this is one way we can find out.
Representative Bolden.
Thank you for taking my question. Do you know, or could you speak to whether repeated exposure to increasingly stronger doses, unexpectedly higher potency of drugs might play into someone's level of addiction or their experience in taking illicit drugs?
You mean specifically like fentanyl?
I guess I'm saying instead of if 1 in every 6 beers kills you, if 1 in every 6 beers is vodka,
right,
and you are an alcoholic, how is your inability to manage the content of what you're consuming, how does that play into the experience of addiction?
I imagine it would make it worse. I mean, I don't know the literature involved in the strength of how it affects it, but I know that if you take more of something, you can develop tolerance for certain substances, alcohol, opioids especially, and as we heard earlier with psychedelic drugs, but they won't kill you. So I think it's important to know what you're taking, no matter what it is. I mean, I put seasonings on my food. I'd like to know that it's not the super concentrated hot sauce my son bought at the spice store in Boston last week, because that was not an exciting thing to find out. Really need to know what you're getting. And one thing, these test strips that we commonly use now just tell you whether it has fentanyl or not. And you can get them for different substances, and that's a great thing to have for all kinds of different drugs if you're trying to test for things. Some places in Europe and around the world have actually had concerts or big venues where they'll have a drug checking station. And we know they're happening in there, and it's a safer, I think it's a great idea. That way you can check and see what people are doing, and they're not going to get something that's going to kill them. The other thing is, well, all right, go. Any more questions? No?
Thank you.
Sure. Thank you all.
Chair calls Kate Frey.
Oh, thank you very much. Good afternoon, members of the committee. I know you've had a long day, so I'll be really brief, and I have written testimony. My name is Kate Fry. I'm the Vice President of Advocacy for New Futures. Here in New Hampshire, we're a nonprofit, nonpartisan organization that works on health and wellness policies in New Hampshire. We work extensively with policymakers, stakeholders, and prevention partners to prevent and reduce alcohol drug problems in our state. But also we work very closely with recovery and treatment organizations as well as evidence-based harm reduction programs. So as we all know, this state experienced, still in the throes, somewhat of an opiate crisis epidemic. It really peaked in 2017 with 490 deaths that year. New Future supported other harm reduction strategies around that time, including making Narcan more widely available in the Good Samaritan Law. Because of these strategies, along with improvements made across the continuum of care for substance use disorders, we've seen a reduction of overdose deaths from 2018 to 2021, while other states have continued to see increases in drug overdoses. Drug testing kits, such as fentanyl strips, is an additional proven strategy to save lives. According to CDC, FTS's fentanyl test strips are a low-cost method of helping prevent drug overdoses and reducing harm. However, the way the law is written now, it would be considered drug paraphernalia. Recent reports, as we all know, indicate that fentanyl is routinely mixed with other drugs. And so HB 470 would allow one more tool in the toolbox as far as being able to test the drugs out there for fentanyl. While we supported a similar bill heard last week, we do prefer this bill because its approach is kind of a much more comprehensive approach to drug testing. So we ask that the committee recommend ought to pass on HB 470. I have my testimony as well as an article from International Journal of Drug Policy that I think you heard a lot about, that I thought I'd just bring you a copy. It has to do with the effectiveness of fentanyl test strips.
Thank you for your testimony. If you want to pass that down, we'll distribute it. The chair calls Lauren McKinley.
Hi, my name is Lauren McGinley. I am the Executive Director of the New Hampshire Harm Reduction Coalition. You might have heard me speak last week on the previous bill regarding fentanyl test strips, and while that is an excellent bill specific to self-testing drugs for the presence of fentanyl or other contaminants, the bill that you're looking at now is slightly different because it is a much more comprehensive approach to our state's ability to identify not just fentanyl, but contaminants that are showing up in drugs right now that can cause, I believe, more harm than what fentanyl has caused us in the past decade. The scary thing with our drug supply right now in our state is that we don't know what we should be most scared of. We have some ability to identify because our neighboring states have been doing supply testing like this for a considerable amount of time, at least 10 years in Massachusetts. As we work closely with Massachusetts and the team at Brandeis University, who leads the testing in that state, we find ourselves at a loss for being able to be at the same level they are for identifying drug contaminants. So this bill is going to provide a safe state for us to be able to start to explore detailed drug testing capabilities driven by participants of people that utilize harm reduction programs. So people that attend harm reduction programs would be able to bring a small sample of the supply that they wish tested, and we would be able to test it and not say yes or no, there's fentanyl, but say there is this much fentanyl, there is this much additional contaminant, there's this much xylazine, there is this much. You need to be cautious of these things. And we'll be able to see growing trends in our state of what drugs are coming in, how they're getting in, and what we need to do about it to keep people safe from fatal overdoses. If there are any questions, go ahead. Yes, Jody.
Representative Newell.
I was wondering, well, first of all, thank you for taking my question. I was wondering if you could talk a little bit about, did you say it's called xylazine? I've only read it, I haven't pronounced it.
Yes.
Okay. I think, most of us are familiar with fentanyl. I think probably all of us are very familiar with fentanyl and the consequences of that. Xylazine is a new one, and I think that kind of, gives us an opportunity to understand what's coming at us in different ways. So if you could talk a little bit about xylazine and the effects of that, the impact of that, and
I'd be happy
I'd
to.
appreciate
Thank you for the question. Xylazine is a contaminant that we know is in our drug supply because we're seeing evidence in it in the way people are experiencing overdoses and the wounds that they're experiencing after utilizing a supply with xylazine in it. So xylazine is a large animal tranquilizer. It is not approved for human consumption. And not only is it not reactive to naloxone or Narcan, as we sometimes know it, it's going to produce a much heavier overdose effect or respiratory effect. It's also going to produce some very serious wounds on the person's body. They resemble burns. And that's going to increase the rate of infected wounds in our state and on our hospital systems. You're correct. We know a lot about fentanyl, and we do know that fentanyl is in our supply. But again, what's very concerning is we don't know what's in our supply currently because we don't have programming like this. I would have loved to have brought a drug supply, New Hampshire drug supply checking professional to come and speak to you about it, but we don't have the infrastructure in our state to set up a program to start to look at our drug supply and what exists within it. So we don't really know what to be most scared of right now.
If I may, you said that there are several things that are popping up. Is there any other thing that's popping up right now in our drug supply that you're aware of?
Yes, there's, so I know that Dr. Nolte is going to submit some data for you from drugsdata.org. So I won't give away her surprise, but anybody is able to go to drugsdata.org. You would be able to look at not just states from all over the US, but from all over the world that take part in these comprehensive testing programs like we are proposing today. New Hampshire will not have data on there. There'll be 4 pieces of data from New Hampshire, and that's it, only because Massachusetts was so kind to test 4 samples of our supply. But every other state around us is able to produce these comprehensive, detailed reports about what is in their drug supply immediately.
Representative Wheeler.
Thank you, Mr. Chairman. So if we pass this legislation, New Hampshire will be able to do a similar drug data set like this?
Yeah, so New Hampshire would start to show up on drugsdata.org and start to compare internationally with what other entities are able to do to keep their citizens safe.
Thank you.
Thank you very much.
The chair calls Carrie Nolte.
Thank you so much to the committee for the opportunity to speak to you. I think I'm coming at a good spot for follow-up. I did provide some printed materials that should be circulated. And does everyone have that? I'll reference that, great. So I'm Carrie Nolte. I'm a family nurse practitioner in community health and an associate professor of nursing. And my work focuses on reducing drug-related harm. I've been very involved with the Harm Reduction Coalition and other, and also police agencies around harm reduction, and working through this. This is really the next step, and I think it's really important that the committee considers moving this forward soon because we don't want to get further behind. I think we're all behind our other states in allowing drug checking, and so we know of, and I know the committee had shared information around fentanyl test strips and rapid test strips. I think one really key point to understand is although there's lots of talk of fentanyl across the state, fentanyl is truly become the drug supply, the illicit drug supply that we have. So in the last, I think it's been 5 years, there have been 1 or 2 heroin-related deaths in the state. They are all coming up with fentanyl, whether they be with other things as well. But we go through these cycles of different things changing, and although strategies like fentanyl test strips come 3 years after fentanyl and can make a dent and help, this is a program that's really going to have us be on the forefront of understanding what's there. I know you just heard about xylazine. I'll try not to be repetitive. You heard about some of the effects of that. In this packet, on the 3rd page, I've provided a clinical bulletin that recently just came out in January from the Department of Safety regarding xylazine, and that in overdose deaths cases, they're seeing positive results for xylazine. On the following page, and I think this gets to what Lauren was talking about and the questions, this is a printout from Drugs Data, a publicly available data set. And I'm not going to go through all 10 pages, but I think just seeing the bulk of it and how many samples have xylazine in it from Massachusetts in the last 3 months is compelling in itself. But I did want to point out, as we've talked about 2 primary substances, fentanyl and xylazine in these conversations, what really is in some of these samples. So if you take just the first 5 samples there, you also see that there's procaine, which is used in dental procedures for numbing. You see there's caffeine. You'll see that there's also quentapine, which is Seroquel. It's used for sleep, psychosis, bipolar disorder, all sorts of things. You'll also see quinine, which you may recall is a malarial drug. So the sedative effects of medications are being combined and cut and all of that. So although now we know in New Hampshire we have fentanyl and xylazine, we don't know about all these other substances, and we don't have the opportunity if new harmful things, even more harmful things are coming into play, what there will be unless we allow comprehensive drug checking. I'm happy to take any questions, but I think you've heard a lot from everyone, and I don't want to be duplicative.
Representative Newman.
Yeah, I just have a quick question. I mean, I see here that it says the drug paraphernalia should not be included in drug checking equipment, and I don't see any other added language to this bill. So I'm a little bit confused about it. I mean, this just makes it not, it's not illegal. But then there was some conversation about the data would be better and the state could start checking and whatever, and I don't see anything like that in the bill. How is this bill connected to getting better and more checking in the state of New Hampshire?
So my apologies, my hearing, I'm still recovering from an ear infection, and I think I heard your question, but please correct me if I'm wrong. So currently, my understanding of the paraphernalia laws are that it explicitly does not allow transporting, sampling, analyzing, testing. And so this bill is aimed at the testers, you know, myself interested in helping to develop a drug checking program. If I'm transporting samples to send to confirmatory testing to drugsdata.org, that I'm not arrested for possession or for paraphernalia for having baggies and things like that. Does that get at your question, or please follow
Can I
up?
just clarify? Yeah, it really does. So it would be private people or private organizations that would not be held criminally now for doing the things that you just mentioned.
Mm-hmm.
And I was under the misimpression that it was, that the state would be doing this. So, well, thank you very much.
Yeah, so my current understanding of state and testing is that they only test samples if they're going to be utilized in court cases. So if it's a baggie for possession, the state has to do an analysis on that. That data is not able to come back in real time. Just anecdotally, I've heard that the waits on that are 3 to 6 months. And so the point of this is rapid, informing strategies, informing information, and therefore reducing overdoses because of that. We will still need to build a program. This is all based on, you know, most likely federal funding and federal grants. But right now those are available to support this, and the team you've seen in support of this would probably be the team to be applying and building that.
Thank you.
Thank you.
Representative Newell.
Thank you for taking my question. I was just curious about, especially because you're associated with the University of New Hampshire. Are these skills being taught to the next generation of nurses and things like that? Or is it something that would be allowed by this bill? I'm just curious how that kind of works out.
May I just clarify, would something like drug checking be taught to be involved students, health profession students?
Yeah, I guess maybe that was a silly question. It's maybe obviously if testing is the same across the board, is this different than testing anything else?
I'm so sorry, my hearing
I'm
is just bad. If
sorry.
someone can repeat the question.
Is this different than testing in other situations where this would need to be specifically taught to nursing students?
I think, I mean, my ideal would be that students would be involved, and this is an amazing opportunity, and it pairs very well with an increased involvement we have of our students in recovery community organizations and other strategies. The training in order to become competent on rapid drug checking, is challenging, but definitely something that those students who wanted to learn that or make that part of their practice could absolutely join in doing. And I must repeat, and I do have it in my written testimony, that my views represent my expertise and knowledge in this and not necessarily the University of New Hampshire, but.
Thank you.
Thank you for your testimony.
Thank you.
The chair recognizes Captain Bill Bright from the New Hampshire State Police.
Good afternoon. Thank you for hearing my testimony on what has been a very long day. I'll try and keep it brief for all of you. My name is Bill Bright with the New Hampshire State Police. I previously testified in the other drug paraphernalia bill. I believe it was last week. That bill was narrow. It was very narrow, and it included removing the words testing and analyzing. I testified that I didn't see any unintended consequences at the time. The one thing that I would like to present as information to all of you as you're considering both of these bills is that the testing and analyzing of these drugs using whatever kits are available or whatever could be used by somebody who is trafficking narcotics. They could use these things to determine what they're getting for products, what the potency is, and things like that. So I just throw that out there as information to all of you, that it is a possibility that it could be used for nefarious purposes as well. As far as the harm reduction standpoint goes, the state police, myself, we are very sympathetic to that mission, and I understand the intent of this bill and the other bill to allow for people who are going to use a substance anyways to determine the potential safety or potential harms. We understand that, but I do have some concerns about this bill specifically. Without it being narrowly, without the narrowness of the other bill, I'll draw your attention to page 2, line 18 and 19. The language that's being taken out of the drug paraphernalia definition is for processing, preparing, testing, analyzing, packaging, repackaging, storing, and containing. So I can foresee some scenarios where, especially packaging equipment, repackaging, storing equipment, containing equipment, where if those items are removed from this definition, we may limit some investigators who are trying to do their job in building probable cause for drug investigations going forward. So that, including that language, I believe will limit investigators from outside of the scope of the intent of the bill. I also think that the bill contradicts itself, as in page 3, lines 34 and 35, the definition for drug checking equipment. It says drug checking equipment does not include the substances being analyzed or drug packaging or drug supplies, where if we're striking out the wording for packaging and supplies in the previous part of the bill, now we're saying that the definition does not include drug packaging and drug supplies. So I think there is a contradiction there. And again, from a law enforcement standpoint, any packaging equipment, any supplies that have to do with, narcotics or drugs in general, that would be important to our mission in investigating cases. And I also do wonder as well about the line where it says drug checking equipment does not include the substances being analyzed. If it doesn't include the substances being analyzed, then as the previous speaker was talking about, there may be some issues there with the ability to test drugs that people bring to them. I also would offer that I believe that our state forensic lab could offer some statistics to, what is included in these drugs already. And there is intelligence out there as far as the trends of the substances that are included in the drugs that end up in our state.
Is that information publicly available?
So some of it is law enforcement sensitive, so I can't offer up, everything that goes out, but those trends are available. I'm sure some of them are available to the public. Most of what I see may be law enforcement sensitive.
Would you see a problem if these agencies that are involved in harm reduction were licensed to do that? And in other words, if all this stuff wasn't made available to the general public, but specifically to agencies that were involved in harm reduction, would that present the same problem?
So I think I would just offer that it may be difficult to set up a situation where somebody can bring an illegal product to one of these facilities to get tested. I foresee that as a difficult situation. The locations, the people coming and things like that. I just would see that as a difficult situation. I do think that in the harm reduction mission, if this was narrowed to a sense that, hey, we know that fentanyl is killing people. Fentanyl specifically put the language to include fentanyl testing strips or whatever the substances are that we identify as the most harmful, rather than just opening it up to any testing or any analyzing. So that would be something that we would take a look at if it was narrow and was specific to maybe not even the potency, but to the presence of a certain narcotic or substance.
Are you able to address the drug or the substance that was testified to that's popping up that's causing these sores, this horse?
The xylazine?
Yeah.
So I have limited information about it, similar to what was already testified to. So I just know that it is present. It has made its way to New Hampshire. It has been prevalent in southern states for quite a while. And yes, it is some type of, causing some sores or flesh-eating issues in the people that are coming across it.
Thank you. Representative Newell.
Thank you for taking my question.
Sure.
I'm curious, in the beginning you had said that you were concerned about, these same testing and analyzing equipment could be used for, cartels or things like that. Is that something that you've come across? And if so, how common is that?
Yeah, I think that if you open it up, you take a tool away from law enforcement in those situations. You're also, as the testing equipment gets more advanced, it's just a tool that a drug trafficker could use. I just want to offer that as information. I haven't seen it recently, but I just offer that up as information, as a potential issue.
Can I ask a follow-up? Just really quick, have you ever seen it?
Have I ever seen testing equipment?
Have you ever had the situation that you're concerned about in finding cartels having testing and analyzing equipment? Is that something that you have come across?
Typically we are, we may arrest a trafficker And it's typically, they have the products with them, the equipment to package, and to distribute, and it's usually a large amount in small packages. The testing equipment, I haven't seen that. I'm just offering it up as that is one potential pitfall of the testing equipment.
Thank you.
Is your understanding of the bill, I know that one of the things you might look for is an abundance in a vehicle of, for example, small glassine packages. Would this allow that now? Would that no longer be used to build probable cause among other items?
Well, I think, packaging equipment is very broad.
Right.
There is a lot of broad language in the drug paraphernalia definition and statute. Those things on their own do not constitute probable cause for a search. So anytime that law enforcement is coming across these things, it's usually because we have already established that there are other things there. So, but that helps build probable cause for, for a judge to say, oh yeah, we do believe that there is something illegal there and you are allowed to search it. So it would just take a tool away. So yeah, in and of themselves, the packaging, containers, things like that, without the presence of an illegal substance, they're not illegal. But when they're used in conjunction with the trafficking of narcotics, then they do become part of the probable cause that we would use.
I'm concerned not only with probable cause, but making your case. If you're trying to make the leap from possession to possession intent or actual dealing, you have to have a certain amount and also packaging material to indicate that this is the intent was to distribute these drugs. By taking this away, would that limit your ability to make a case of
you make a good point. I believe that it could, yes.
Okay. Thank you. You have a question? Go ahead. Okay, Chief's question.
Thank you for taking my question. Thank you, Mr. Chair. I was just wondering if there was language changes that could be made to this bill that would leave it more open to testing for other substances beyond fentanyl that the police department would find more amenable.
So I think, just a suggestion would be to identify the substances that we're most worried about, whether that's fentanyl, heroin, methamphetamine, things like that. And, like if you were very specific about those things, we would look at that language.
So like xylazine?
Xylazine,
okay.
Yeah.
Representative Wheeler.
Thank you, Mr. Chair. I just want, for clarification, I think you might have mentioned in orientation, but is the state police taking a position on this, or do they generally take positions?
So I opposed this one. I was neutral on the last one. I opposed this one because of how broad it is. So that's my position on this bill specifically, the way it's written now.
There be no questions? Thank you.
Thank you.
Is there anyone else wishing to testify on this bill? There being none, I'm going to close the public hearing on HB 470. Representatives, please stand by for a caucus. Who's, you mean our folks, right? Okay. Except for Democrats.